Mm.
You cannot start your video because host has stopped it. Isn't it?
திருமொழியின் அருமையான வரிகள். தந்தை இருந்தால் பாரம் இல்லை, தந்தை காட்டும் பாதை தூரம் இல்லை.
Sound is
Proceed in the appeal, again it will be granted.
It was, this matter has been
No,
filed in
no
January,
urgency in
my lord.
grant of land, yes.
It was never listed, my lord.
But you wait for 5 days and then mention if it is not listed.
Commissioner, that was allotted for the direction for each of the land. That order has been challenged by the petition before this honorable court. So this honorable court, single judge has allowed the application and allowed the petition and set aside the order passed by the regional director. Hence we are found their presence.
So usual appeal, it will come. Wait for 5-6 days. It will- Suffering by,
Any date, my lords, any date after 2 weeks, my lords.
you wait for 5-6 days. If it is not listed after removal of mention again. You wait for 4-5 days. If not listed in the meantime, again mention.
Issue notice, it's not getting served, only to give the new address, any convenient day, not saying today, tomorrow, any convenient day, only to give new address. I'm seeking an urgent order, Lordship.
29th.
Lordship.
Your Lordship, kindly,
Yes,
serial number 94, my lord.
94.
It is a PIL matter about the 3 times the matter has not been reached, and I have submitted before your Lordship regarding the objection about it is in accordance with the rule of the writ proceedings rules. Your Lordship kindly dispense with it, quote it for preliminary hearing, my lord.
What is the objection?
Objection is in accordance with the rule 14 only. I have noted, my lord.
PIL rules are not complied.
That is complied. What I stated is that what I
At
submitted
least
has
list
to
it
accept
on-
before your Lordship.
7th November will be listed, due for reading, including state 7-11. Yes,
Preliminary hearing, my lord.
whatever will not
No,
list
that
it.
matter 4 times I have waited, my lord. Not matter.
What else it is done? 7-11 for what purpose?
I have noted, they have stated that they have to be
So
accepted.
we have said 7-11.
But my submission is that kindly dispense with the
For what else it is listed on 7-11?
for preliminary hearing.
For what else it is listed? Yes,
Number 89, I have completed the artist objection, now they have raised it.
serial number
89,
89, yes.
I have completed the office objection, again they have raised it, I may be given 1 week time.
Pardon?
I may be given 1 week time to,
Time? It is non-compliance of office. So office official shall be removed within 2 weeks.
My lordship, the contempt petition, my lordship, the complainant is a retired professor. He hasn't received his pension amount for the past 10 years. The urgency is that the amount is the sole purpose of livelihood, my lordship. So the matter could be listed to your convenience, my lordship.
11th November.
Please, Your
Lord, in November 23, the Enforcement Directorate had issued summons to an accused who is the former managing director of a district cooperative bank, and he was facing allegation of scam of recruitment. There are cases registered against him under the Prevention of Corruption Act.
Allegation of?
Corruption under the Prevention of Corruption Act, and also cheating. So since there was a predicate offense, we issued a summons to him in November 2023. He challenges that in a writ petition read with 482. And he says the predicate offense is stayed in another section 482 petition. The learned single judge hears both the petition in detail, dismisses all of them. And my lord, against the dismissal of the writ petition in which he had challenged my summons, he files a writ appeal, doesn't produce the copy of the order. And then on that basis, your lordship until then had granted stay. He has not complied with that office objection. So it is getting listed in the orders at the end. But in the meantime, my lord, our summons, my lord, at the very preliminary stage, someone who has committed a serious offense is not getting listed.
So
Your lordship take it up under
Writ
admission.
appeal is filed by you.
No, he has filed the writ appeal. A writ appeal is not maintainable, my lord. It's a quashing proceedings. He sought for quashing of the summons. But
Arising out of-
because of this stay, we are not able to proceed with the investigation, though the summons were issued in November 23.
It is listed today.
No, it is not listed today, my lord. Some date, the registry had given some date in November. Would your lordship have it in the admission category anytime next week?
Why don't you file a memo?
Memo is ready, my lord.
File
29th, my lord, I have sought for. 29th October,
28.
28th, my lord, I mean before the Kerala High Court.
Then,
Either 29th or 30th, my lord. Or would your lordship have it immediately after the first week of November?
5th, 4th or 4th.
Yes, my lord, 4th.
4th.
4th. I'm grateful.
PL number 25, my lord.
I'm, this is the contempt petition. I'm for the complainants in this case. My lords, on 30th/7/2024, my lords have directed the accused in WP number 10784 in order to register the deed of declaration along with bylaws in the concerned Karnataka Apartment Ownership Act. But they have still not complied with it, my lord. Kindly post it for admission hearing, my lord. Coming 23rd, my lord.
Wait for week, you will list it.
My
Once
lord.
you remove your-
Urgency is there, my lord. Apartment owners cannot maintain it without the registration of the association.
Wait for 5, 6 days. Then mention again if you not listed. Yes, anything?
My lord, CL number 25, my lord. CL number 25. For appellant, my lord, inform the other side. Praying for weeks time.
my lord.
Pardon?
CL number 25, my lord. Praying for appellant. Inform the other side, my lord. Praying for weeks time, my lord. Some small inconvenience.
25 will go to 13th November.
Obliged.
Your lord.
Serial number 82, my lords.
18th.
I have served the copy to the respondent, my lords. Acknowledgement also filed yesterday. Place for a short accommodation, my lords, with a week's time. Serial number 82, my lords.
82. 20th November.
Much obliged, my lord.
Your lordship, serial number 61, your lordship.
61.
Office objection has been raised for the, on the
61 is not office objection.
61, your lordship.
61,
61.
yes.
Office objection has been raised on the counter affidavit. Kindly 2 weeks of accommodation may be given. I'll sort out the.
2 weeks are granted to remove the office objection. Pardon?
And where the taken the possession and she's a widow.
No, without removal of office objection, we will not permit. First you remove, then mention.
My lords, please, my lords.
Yes.
I'm the appellant, my lord. I'm being disentitled from.
We have said no, you wait for 4 or 5 days, get it listed, then mention.
Obliged.
Repeat mention will not change the view of the court.
Obliged.
Yes.
Contempt matters, CC number 1, Mr. Patta BC.
November.
I'm appealing for the complaint in this case. 189 days delay, my lord. The delay may be condoned.
How can there be delay in contempt matter?
My lord, the
It
person,
is time,
the
it is
person,
time barred then.
yes, but the person who demolished my building, I am not aware who has the demolished.
So which order page you are?
In the civil, is original suit, in the High Court, there was a stay. maintain
Page,
status quo.
page. Order. Which is the order under contempt? Page 122.
Yes, my lord.
It is passed in 2020.
Yes, my lord. The
21.
order was in force. They have demolished the building.
So what is there to challenge in this order?
But I filed the bare injunction suit, my lord.
Pardon?
It was dismissed. They filed the appeal, wherein the order was passed to maintain status quo both the parties. When the order was enforced, they have demolished the building and admitted in the court, yes, we have demolished, that the schedule is totally different, yes, we have demolished. But in the trial court, they admitted that it is constructed by me.
Heard learned advocate Mr. Pattabi C for the complainant. The present contempt petition is filed in respect of order dated 7/9/2020, passed by on a single judge in regular first appeal number 802 of 2020. What is the number? With RFA 932 of 2020, which was for injunction. Full stop. Thereby, on a single judge directed the parties to maintain status quo pending the disposal of the interim application. Paragraph. There are three independent reasons because of which the court is not inclined to entertain the contempt petition. Firstly, the order is dated 7/9/2020. Full stop. In terms of our section 10 or 20? 20 of the Contempt of Courts Act 1971, the contempt proceedings are required to be filed within a period of 1 year from the date of the order, and the arisal of cause of action to complaint of breach of the order. Full stop. Since the period of 1 year has already expired, the cause of action has no more survived for the petitioner to invoke the contempt jurisdiction of this court. Paragraph. Secondly, the order is interim order. At this stage, no rights of the parties are rights of the end of the parties are not finally crystallized. The appeal is at large for merits to be considered by a single judge. Thirdly, since the order is interim order, the petitioner has remedy under Order 39, Rule 2, capital A of the Code of Civil Procedure 1908. Full stop. If available in accordance with law, said remedy could be availed by the petitioner. Full stop. Without expressing any opinion on the merits of such recourse, this petition is dismissed
This.
accordingly. Yes, next.
So number 2, Mr. Abhinay Vaiti.
Yes.
The complainant, my lords, the order passed by the learned single judge is at page number 12, my lord.
Notice returnable on 14th November.
Much obliged.
So number 3, Mr. Chandraya.
For appellant, my lord. This honorable court has passed an order to reinstate me for the post of waterman committee. But I was not appointed despite
Not reinstated.
not reinstated.
15th November.
Delay is also there.
Pardon?
There is a delay of 440 days.
Delay in contempt.
Yes,
There is no delay. It is either maintainable or not maintainable.
office has made
Which
note
is
of it.
the date of the order? 21. Let us see.
Much. more.
Notice. Seal number 4, Rajesh Kumar, yes.
Lord, appearing for the complainant, my lords. Lord, the order passed by the learned division bench is at page 41, my lords, whereby the auction sale is set aside. And I've been directed to pay a sum of 3,41,07,747. My lords, I had approached the accused bank on 25/3/2024, which can be found at page 219.
Not refunded.
Not refunded, my lords. I have not received the refund amount from the DRT. I've approached them as well as the bank funds.
November 20.
My lord, any date earlier, my lords, the estate
Earlier,
coffee plantation.
12th November.
12th November.
Seal number 5, to Colin Kenneth, third party in person.
What is?
I'm the complainant, my lords.
I'm for the respondent, accused, my lords. Last time, there was an order that I should comply 6 times. I mean, on every Sunday, that child visitation was allowed. My lords, now there is an objections I filed, my lords, along with the criminal miscellaneous, where in that order, my lords, there is a maintenance of 8,000 rupees to the child is granted in the year 2018. Since then, he has not complied, my lords.
So there was some, that order was continued by us
Yes,
of meeting in the mall.
my lords.
Yes, my lords.
Do you
Phoenix
met-
Mall and
the
Care.
Parties met or not?
Yes,
Met once.
please, ma'am.
So what is to be done now? Yes,
Yes.
madam.
Sir, two requests. I don't mind taking for the visitations. One from the child perspective, child is actually feeling that she's not been heard. Her emotions have been masked and I've been continuously taking her to the counseling.
Child is mentally disturbed.
Yeah.
Yes, my lords, that was happened.
So if you remember last time also, she was
Last time-
smiling a lot.
Last time this.
My lords, my daughter's name is Nina India, if you remember. 5 visitations were granted. I filed a memo in the counter today. It may not be on the files with pictures and everything that happened in the mall in detail, my lords. The daughter is comfortable. Initially, it is my, I also have to bring it to my lord's notice that initially for about 5-10 minutes or maybe 15-20 minutes, she's a little reluctant to meet me on the initial stages,
According
but
to you,
post that
the-
she's fine.
Daughter was there, daughter?
Yeah, daughter.
Yes, ma'am.
Daughter is not willing to meet.
No, it is not about willing, my lord. It is about having that reluctance of why should I meet? So,
Louder.
so the baby is actually feeling very reluctant and masking the emotions about why should I meet him? And the second point is my emotions are not being considered.
And even she has written a letter, my lords.
My lords, this is a matter where an extended delay happened before the visitations were granted. So the daughter was with me for 1.5 years and then separation. And when she turned 8, that's when the visitations are granted, my lords. In my perspective, the baby is comfortable. I only need some more time to have this taken care of.
Where is the order? Page?
Order of miscellaneous. Lords, there are 2 orders.
It is on page 13 of my ink book. Order dated 10th March.
Sir, where is the order? Page, order.
Lords, that is criminal miscellaneous in page number 10, my lords, along with objections I have filed. And there is one more appeal was
This is the
filed.
page of the order which is under contempt.
10.
You are a lawyer.
Page number, which is that?
Page number 10, my lords.
10.
Along with the objections I have filed.
Order.
Yes, my lords. Where in that, my lords, maintenance was ordered to the respondent, I mean, my lords, petitioner, child, it was not complied. My lords, then thereafterwards, I have sought for modification of that order. I mean, the visiting rates was sought for challenge. I challenged that visiting order, my lords, and that also in the page number 12. In criminal appeal, there is an order which says that, my lords, I have to give the visiting rights. And I was ready to comply that, but the thing is, child, please, no.
Page 18 is the order.
Page number 12, my lords. 10 and 12, my lords.
Same.
Please.
This is the order. Read the order. Read the order under contempt.
Please, my lords. My lords, in that, my lords, I have filed an appeal, my lords, that was dismissed, my lords, and the respondent is directed to pay.
Read it with the order. We are not able to find out.
My lords, in page number 23.
Because it is filed by party in person.
Is
Where
it
is the
okay if I
order
can
with
read
the party in person is complaining? Page 18?
Page number 23, my lords.
23.
Yes, my lords. My lords, my appeal was dismissed. I sought for modification of that order, my lords, which is the order passed by the first MMTC in Mayhall at Bangalore. And in that, my lords, the respondent was directed to pay the arrears of so-and-so. And my lords, and my appeal was dismissed that I should comply. I should comply the visiting rights which is ordered by the matrimonial magistrate in at Mayhall in Bangalore, my lords. And there was a specific direction to the complainant, my lords, to pay the arrears within 2 months, my lords. That was also not complied by the complainant.
My lords, there are a couple of instances that I will have to bring to your notice. I have applied. I agree that the learned advocate has challenged the order. He has challenged in sessions court, which was disposed. Yes, the sessions court had granted me visitation.
The mother is saying to the court that your daughter in meeting with you faces some psychological issues. So she has to be treated psychologically.
So they have been claiming the same.
Indirectly, the submission is that it is not possible for the daughter to meet you.
Very true, my lords. My humble submission is they have been claiming the same since the start, even before my lords were kind enough to grant me a few visitations that were granted. They claim that the school had given them a letter, which is not before me or before my lords. Then they claim that the doctor has given a prescription or she's going through the therapy sessions, which I inquired with the mother. She's gone through 3 sessions at Aster Hospital is what was informed to me. And it was also informed that the baby is doing good. I am not a child specialist, my lords. I'm only meeting my daughter after an extended period. In my perspective, the daughter is doing very well. I've produced before my lords the photographs and videos and everything that I had from the previous visitation, and the most recent visitation also I filed it this morning, my lord. My only request. My lords, I will be more than happy to assist the psychiatrist or the counselor that she is referring to as well. Anything that I have to do as a father, I'm ready to do that, my lords. From my perspective, the baby is okay. I've met her a few times. Maybe a couple more times, the baby will be comfortable again, because there is an extended period of disgraceful lull period where I could not meet the daughter and the daughter could not interact me. Even going one step further, the father's existence was removed from the daughter's life, my lord. The
My
name
lords,
has changed,
correction
everything
there.
has changed. So when the daughter does not even know my name, know my existence, the daughter will have a little bit of hindrances to meet the father. I'm only a stranger to my daughter until these visitations are granted by your lords.
My lords,
My
I have
lord's
filed
submission.
one memo along with the documents. Kindly see page number 18, my lords.
Heard complainant party in person, Mr. Colin Kenneth Ward, WRD. And learned advocate, Mr. So and so, the respondent. The present contempt proceedings filed by the petitioner father arises out of order dated 10/3/23 passed by learned Court of Metropolitan Magistrate, Traffic Court number 1 at Mayo Hall, Bangalore. In the proceedings of civil business application number 245 of 18, which was an application filed by the respondent mother under section 21 of the Protection of Women from Domestic Violence Act. Full stop. Learned judge, while allowing the said proceedings in part, comma, gave liberty to the respondent husband, that's the petitioner hearing, to visit his daughter. What is the age? 7 years?
8 years.
8 years. 8 daughter, aged 8 years, named Kumari Nina India, INDY, Ward, WARD, at the convenient place and time fixed by the petitioner and respondent on 2nd and 4th Saturday every month. Full stop. Alleging non-compliance of the above visitation right, comma, the petitioner party in person, the father, comma, when moved this court, invoking the contempt jurisdiction, comma, following order came to be passed by this court on 12th August 2024. And for the entire order. Full stop. Strenuous efforts were made by the court, not only in respect of compliance, not only with respect to acting upon the directions in the order of the Metropolitan Court, also towards global reconciliation of matrimonial disputes between the parties, keeping in view paramount the interest of the welfare of the daughter. Paragraph. On 20th/9/24, paramount, full stop. The court held interaction with the party and also with the daughter, with the child, with whom the court interacted in absence of the parents, comma, in the presence of the lady court officer. From the staff of the registry of this court. Thereafter, on 20th/9/24, Further order was passed. Third error. The said order reflects the total proceedings. Therefore, the same is reproduced herein. Then quote the entire order. Today, when the contempt proceedings came up for further consideration, it was submitted on behalf of the respondent mother that although the meeting at the mall took place between the parties and the petitioner could interact with the child to spend SPND time with the child, according to the respondent mother, the child thereafter developed psychological stress, and that, according to mother, she is required to be treated for counseling. It was submitted that it was thereby sought to be submitted that any further meeting with the father may affect the psychological health of the child. On the other hand, the petitioner part in person, the father emphasized to submit that his daughter was always comfortable with him in spending time with him. Full stop. It appears from the stand taken by both the sides that there are serious issues about exercise of liberty given by the court below to the father to meet and interact with the daughter. This court, having undertaken the aforesaid exercise, and to endeavor the compliance to the maximum possible extent, finds it difficult to further act upon. The reason that the issue involves not only the interest of the child, but the delicate aspects of human and matrimonial relationship in the context of rights of the parents toward the child. Full stop. This court can only hope to expect that the parties arrive at a mutual understanding voluntarily on all possible counts to ensure that the psychological, physical, and educational well-being of the child is not adversely affected in wake of institutive stance Full stop. As far as the present contempt proceedings are concerned, they are, however, liable to be closed in light of what has transpired so far and what is observed herein. Full stop. There is no gainsaying, paragraph, that the order of the Metropolitan Court subsists to operate, which gives liberty to the applicant father to have visitation rights to the daughter as provided for. Full stop. The parties have met at the mall pursuant to the orders and directions issued by this court. Subsequently, but the impediments are shown to be arising in continuance of the state meeting. In the circumstances, paragraph. The respondent is permitted to apply to the Metropolitan Court concerned for modification of the direction, which could, however, be done before the Metropolitan Court only by producing relevant material in substantiation of the fact pleaded that the child's meeting with the father entails psychological effects on the mind of the child. Full stop. It will be open also for the petitioner husband to put forward his case before the Metropolitan Court by appropriate material. Full stop. By considering such material and the totality of the case, the Metropolitan Court shall decide about the variation or otherwise of the order dated 10/3/23. Full stop. This court does not express any opinion on the merits of the submissions recorded as above, made by both the sides in respect of their rival claims. With the aforesaid observation and permission to the parties, the contempt proceedings are closed.
My lords, one request, my lords. Last date, my lords had given me 6 visitation, 5 done, 1 pending. My daughter asked for a bicycle. Next 1 weekend may be extended as a request, my lords.
At this said learned part in person wanted.
Trial court matter is on 26th. This 26th, my lords.
Is 26.
This
26.
Yes, my lords.
Yes, my
please. Let us file the application.
This state learned part in person requested that the arrangement of meeting at the mall by the father to the daughter may be continued for 1 week.
One last meet. 6 was granted, 5 executed.
The court could have.
My lords, one submission.
The court is not inclined to consider the said request only for the reason that the matter is slated to come up before the court below on 26th of October.
Yes.
That is 3 days. That is 26th October. Full stop. It is observed that on that day, it will be open for the petitioner hearing to urge the request made before this court.
Grateful.
To seek appropriate orders on merits.
Please.
Too grateful. Thank you.
Number 6, the PL matter, the Murali Krishna Brahmandaram Number 6. My lord, this. My lord, paragraph 1 of the writ petition may be seen, my lord, paragraph 1, paragraph 7, and the second prayer.
No, this will not dispose of, right? Keep that. We want to know who has filed this.
Number 7, Mr. J.R. Mohan.
Very for the petitioner's minutes in this case, my lord.
What is this PI? All PI?
My lord, this writ petition is for a direction to the respondents to establish courts of law in the 3 newly formed Taluka headquarters of Kambala, Bidar district, my lord. My lord, this
There is a direct judgment that shifting of headquarter cannot be subject matter of public interest.
it is not about the shifting of the headquarter. It is about establishment of
The
civil
case
courts.
of a court building somewhere, possibly in MP or there is a direct Supreme Court judgment, 2-paragraph judgment. Reported in a year, we'll find out.
It is, okay.
Before we find out, dismissed. Next. There is nothing. It can't be a subject matter of shifting of the headquarter of a office. It is purely.
No. It is not shifting, my lord. It is establishment of the new headquarters, civil courts.
New headquarter, shifting, all are not the common.
In the year 2018, my lord, the 3 new talukas were
Directing
formed.
respondents to set up new courts of law. You have made a representation.
Yes, my lord.
You pursue it, will permit you to pursue it.
With that observation, it may be disposed of.
Will
To
be-
consider my representation, that's all. That is the only prayer.
Because of within 10 weeks.
10 weeks, my lord.
And another 2 petitions are about development of the roads, my lord.
Our learned advocates.
My lord,
Mr.
may I
Francis,
make one submission,
this
my
is a
lord.
public interest petition filed by the petitioner who projects himself to be a public spirited person and social worker. Goes to the prayer. Advanced is to direct the respondent authority to set up new courts of law at the newly formed Taluka headquarters, which are Kamal Nagar Taluka, Hulasura
Hulasura
Taluka,
and Chittagurpa.
and Chittaguppa Taluka, Bidar district. By considering the representation dated 4/10/23, which is already made and stated to be pending before the competent authorities. Having regard to the subject matter, grievance raised in the petition and keeping in view that the representation dated 4/10/23 is pending and still not decided, it will be in the fitness of things to require the competent authority respondents to look into the representation and consider the same in accordance with law to decide the same within 10 weeks from today, full stop. It is clarified that this court has neither gone into the merits of the case of the petitioner, nor has expressed anything about the merits of the grantability or otherwise of the prayers. The petition is disposed of accordingly.
So number 8.
Like this petition is about development of the road from Kamala Nagar to Balur and Mulga villages, my lord.
My lord, annexure A may be seen, my lord. The Honorable Chief Minister, Forest Minister, and the Chairman have been made parties in person. Annexure A, my lord.
My lord, in the writ petition, they are not the parties. Only in the
Representation is given.
The representation is
My
given.
lord, they want that representation to be considered. Them, my lord, the Honorable Chief Minister, the Forest Minister, and the Chairman have been made parties in person, so mandamus, my lord.
All that you in order or you want to pursue representation? There is a judgment. Road building, construction of road.
My lord, the Chief Minister and the other ministers have not been made as parties in the writ petition.
My lord,
The
the names are
recommendations were given to
mentioned in
them,
the
my lord.
representation.
By your standing.
For the board, my lords, I'm for the board, my lords. Not yet received the notice.
By your standing.
Please.
Sit down. So are you inviting order? It's very clear. Give the order to him. Give to the council. You copy. You said the construction of road, alignment of road, repair of road, maintenance of road is not the domain of public interest, purely executive function. So
My limited prayer is to consider my reputation, that's all.
My lord, that representation contains the name individuals, my lord, please. If the page is not numbered, my lord, it's annexure A. Representation is dated 5/9/2023.
now same
Petitioner.
same petitioner of earlier petition. Now same person is filing several petitions.
Yes.
Yeah, yes, my lord.
One
But
for-
the cause of actions are different, my lord.
One for establishment of court, the other for laying of road, the third is for inviting cost.
My lord, another one is to
No,
develop
my
the
lord.
Kacha Road, which is at serial number 9.
4 matters. Fourth is for withdrawal after an imposition of cost. Third, learned advocate, Mr. So and so, the petitioner claiming to be a public spirited person and a social worker, wants this court to issue a writ of mandamus directing the respondents to develop the roads from Kamal Nagar Taluka headquarter, Bidar district, to Balu and Muruga villages, Kamal Nagar Taluka, considering the representation dated 5/9/23 already made by the petition. Full stop. The construction of road, from alignment of road or repair of road, etc. And the functions of such nature purely lie within the domain of the executive. Full stop. Any of the decision of this court in Sri Irana versus Union of India, which was writ petition number 5201 of 2024, decided on 15th April 2024, such grievances cannot fall within the public interest jurisdiction to be invoked before this court, and the public interest litigation would not be liable to be entertained in that regard. However, paragraph, learned advocate for the petitioner in course of the submission submitted that he may be permitted to pursue his representation already pending before the competent authorities. In that view, while not entertaining the petition, the petitioner is at liberty to pursue the representation dated so and so, representation dated 20th/9/23.
My lord, it's 5/9/2023 and next.
5/9/20. The competent authority respondent shall consider it the same in accordance with merit and to consider in accordance with merits, disposed of accordingly without expressing any opinion
Number 9.
in relation to the grantability or otherwise of the request made in the representation.
This is also a similar matter, my lord.
Same order. But the sentence will be, wants this court to issue writ of mandamus directing respondents to develop the Kacha Road from Bhavani
Bijilgaon
village to
Sanganal Cross.
Sanganala Cross, so and so, special representation is 20th/9/20. The rest of the thing will be same.
Grateful.
Seal number 10. Chakki Siddhavir. Seal number 10.
Where is the counsel, Mr. Mohan? Keep it.
Number 11. Anupama G. Abba.
No, I appear for the petitioner's counsel. This PIL, my lord, is with respect to a sport.
2014. 2014.
7 SSC.
7 SSC.
547. It's there. 131.
Is there? Both are there.
Both are there. 131. I've produced the.
There is 2023 9 SSC.
Yes, I have that at 213.
213, both there. So
Both
first,
orders are there.
just I wanted to see the.
Yes, ma'am.
We
My
wanted
lord,
to see the-
before my learned senior can proceed,
Now this event is organized by the fifth respondent.
Event is organized, my
Third-
lord,
third
from the
respondent.
third respondent. And permission, my lord, is then sought from the state government to carry it out. Because the state government has to give permission to do it.
What is this event?
It's called Kambala, my lord. Kambala is a bullock race.
Bullock
where
race.
two bullocks are tied and then they are made to run, my lord, in the fields. My lord, there's no dispute that it is steeped in tradition.
So two bullocks are
tied together. And a person, my lord, makes, if your lordship sees page 273, the photograph is there. 273.
my lord.
A rope, my lord, is put through the nostrils. And then, my lord, there is a stick.
It is called Kambala or Kambala?
Kambala.
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 My lord.
Lord, so far as now with the orders, my lord, of the Supreme Court, one thing, my lord, there is no dispute about is that these races can be held in Udupi and Dakshin Kannada districts.
Now the earlier decisions in respect of the very event Kambala.
Yes, my lord. This very issue was there before the Supreme Court because an amendment was brought to the Prevention of Cruelty to Animals Act by the state government by making Kambala an exception to it.
By
making Kambala as a sport as an exception to it on the ground of tradition and culture. Supreme Court upheld it. Then what is left, my lord, is where can it be held? It can be held in those places where it is the tradition and the culture of that place. In this case, my lord, they have filed an affidavit before the Supreme Court.
But you are trying to contend as far as the first reading of the petition showed that it is being held for commercial.
Yes, yes. In Bangalore, when it is held.
How do you say it is for commercial purpose?
Well, I'll explain, Lord. The entire scope, my lord, of Kambala and where it was being held all through for maybe hundreds of years is only two districts. One is in Udupi district and second is Dakshina Kannada. And Lord, this is not a statement that we are making. The state government filed an affidavit before the Supreme Court.
Sir, submission that in these two districts they can be held, it can be held by out of cultural.
Yes.
What is there to show this?
Their own affidavit. The affidavit of the state government filed before the Supreme Court. Can I request, my lord, to kindly come to page number 63, my lord? 63. In the petition filed by us, Please come to, my lord, page 83 now.
Now, this petition is the reported decision in this.
Yes, yes, it is part of it, my lord.
Which one? 14?
The 14, not the 14 one,
No, 23. 23.
23 one.
Like,
There were several petitions, my lord. One of the petitions were filed by the Animal Welfare Board of India. We had also filed challenges.
no, this is people for ethical treatment of animals.
Yes, that is us.
So is it reported judgment?
Yes, my lord, it is. Your lordship will see the number of writ petitions which are there at page 213. There are a number of writ petitions.
No, no. Is this judgment reported in SCC? That is what.
I'm sorry, ma'am?
Is this judgment at page 63?
Yes, not 63.
It is not a judgment. It is a petition.
This is the objection statement not filed by the state government to our petition, which is part of the connected cases.
It is part of the connected.
Connected petitions before the Supreme Court.
They are reported in 2014? Or
Yes. 2023.
U23, not 14.
Not 14, 2023 order.
23, volume 4.
23-9 SCC.
9 SEC. My lord, if my lord comes to page 213,
Yes.
my lord will see the lead petition was Animal Welfare Board of India.
Correct.
Then my lord will see, if your lordships come down, the fourth line at the top, writ petition civil number 1152 of 2018. My lord found that? 1152. Please see the objections filed is in 1152. In this objection statement, my lord, they specifically make these statements. May I take your lordship through a few paragraphs? Page number 11. Animal Welfare Board of India. What is the 9 SEC? No?
322. (2023) 9 SCC 322. Animal Welfare Board of India.
Do you have the SEC? Take out the SEC.
Yes.
May I request my lord to kindly come to page 83.
Page
83, my lord, of the objections filed by the state government to our petition before the Supreme Court. May I request my lords to kindly come to para 42.
Yes.
Kambala is being termed as one of the folk religious sports event of the coastal district. It has got its own traditional custom which is being followed from centuries. Kambala is an event which is termed as socio-economic and religious festival. In olden days, Kambala used to be performed for months together. The origin of word Kambala has got a different and definite meaning. Kamba means slush field and Kala means a vast land which joined together becomes Kambala. There will be a religious and traditional functions prior to 15 days from the date of the Kambala event. Owners of the buffalo will treat the buffaloes with utmost care and jockeys will get proper training in racing the buffaloes. Then, my lord, I request my lord to kindly come to para 56, my lord, at page 90. The averments set out at so and so are not correct and interpreted for the benefit of the petitioner. Further, it is submitted, Kambala is held only in the coastal district of Karnataka. Dakshina Kannada and Udupi where buffaloes are used in slush track racing, which is a traditional sport in that area. The ears or other organs of the buffaloes are neither mutilated nor tormented. Hence, there is no violation of one or more of the 5 freedoms at any given point in time. Kambala does not involve any violence. It is submitted. Kambala event in Karnataka is nothing but slush track buffalo racing, which is a traditional sport in coastal districts of Karnataka, such as Dakshina Kannada and Udupi. In fact, the buffaloes are being fed with nutritious feed. And this statement, my lord, is made in several paragraphs in the petition. And then at para 62, they say, specifically coastal districts, Dakshina Kannada and Udupi. And then para 64 at page 105. Para 64 at page 105. It is humbly submitted. Basically, Kambala does not involve any violence on animals. It is submitted that Kambala is held only in the coastal district of Karnataka, Dakshina Kannada and Udupi, where buffaloes are used in slush track racing, which is a traditional sport in that area. Udupi. No, there are about 20 references of Udupi and Dakshina Kannada in the affidavit that is filed. Now, for the first time in 2023, my lord,
The Supreme Court at any point of time prohibited this event?
Supreme Court not found it as a cultural event.
Not prohibited entirely.
No. This initially, but Nagaraja's case, Supreme Court said it is cruelty to animals, which is why an amendment was brought to the act by the states, 3 states, my lord, Maharashtra, Tamil Nadu, and Karnataka. Jallikattu, my lord, is in Tamil Nadu, Kambala in Karnataka.
Same.
Jallikattu, my lord, is actually a fight with the ox.
Fights with the
ox. It is like, my lord, the Spanish bullfight. This is an actual tying of the bullocks and making them run in slush fields, which is never done, my lord, before, except in 2023 for the first time it was done in Bangalore.
But then who will determine that there is no violence to the animal?
That, my lord, there is, as a matter of fact, if your lordship kindly comes to a notification issued by the state government.
No. It is a rival case that somebody will say that this itself per se amounts to violence.
Yes. That is our case still.
It will say that it is not a violence because the ears are not tormented and that not tied and whatever. So the buffaloes are dealt with care and every possible dignity.
Yes, my lord. Now, what happens, my lord?
How we will decide that? Who will decide that? On what basis that we decided?
My lord, on cruelty to animals, there are certain provisions in the Prevention of Cruelty to Animals Act itself that you cannot use this for entertainment purposes.
For?
Entertainment purposes.
Itself is cruelty.
Yes, it is cruelty by itself. Our case, my lord, is we have filed a review petition challenging this order, which is pending in the Supreme Court, which is why, my lord, we are before your lordships only on one.
No, today the Supreme Court permits.
Yes.
By saying that probably that the event does not involve cruelty and that secondly, it is held in this area only.
Yes.
So that is clear that this is held in this area only.
Correct.
But then who will decide that this event by itself amounts to or doesn't amount to cruelty?
Now that, my lord, what Supreme Court has said, the lordship kindly sees the last paragraph of the order of the Supreme Court. Supreme Court. That's the only direction which is there. Para 47, my lord, of the Supreme Court of the SEC reporter at page 375. para 45.2, my lord.
Parameters in law should be complied with.
That's all.
Which will amount to non-violence.
That's the, no, they don't say
That much it is said.
45.2. Para 45.2 at page 374. The last few lines, my lord. The last line in A Nagaraja, it says.
In terms of Tamil Nadu rules.
Yes. Jallikattu, my lord.
Yes.
And then if your lordship comes to the last line of para 45.2, last line.
45.2.
2.
Yes.
Last line. In A Nagaraja, the sports were held to attract the restrictions of section 3 and 11(1) A and M of the 1960 Act because of the manner it was prescribed. Practiced. Amendment Act read with the rule seeks to substantially minimize the pain and suffering and continue with the traditional sports. Therefore, all that is ultimately, Nagaraja was not found to be wrong. Supreme Court ultimately only held that you've minimized the amount of, now, my lord, please see the situation. It is not that it is going to be done only in those places. Now they've said they'll do it in Bangalore, they'll do it in Shimoga. Now, these two places, in my respectful submission, require these animals to be brought by trucks from Dakshina Kannada to Bangalore, traveling 300 kilometers, and then they'll be made to run in this race.
This Nagaraja was not in context of this event.
Jallikattu. And Nagaraja, my lord, actually said it is on that basis, my lord, this honorable court had restrained them from carrying out Kambala.
Pardon?
At that time, my lord, we had filed a petition for PETA before this court on the basis of Nagaraja's case. Then this honorable court stopped Kambala as a sport at that point in time. That's at page 191.
But then the Supreme Court said that this can be, the event is held at these places only because it is a cultural.
Part of the culture.
Very good.
Yes, lord. No, places were not identified.
No. Supreme Court has said that.
Supreme Court has said, my lord, if your lordships kindly see, that it is part of, insofar as Karnataka is concerned, page 267. I'm sorry, of the petition, and in this, my lord, it's at para 46.
No, you are showing the stand of the
State government.
State government. But whether it is translated into a kind of
No.
finding or
No specific finding, my lord. There's only one finding, which is at para 46. I showed, my lord, 45.2, where it said it's part of the tradition, because tradition was the entire argument advanced before the Supreme Court. Now, please, para 46 of the Supreme Court judgment. Our decision on the Tamil Nadu amendment would also guide the Maharashtra and Karnataka Amendment Acts. We find all three to be valid legislations because the legislation was challenged. The amendments brought about to make Kambala an exception, my lord, was challenged before the Supreme Court. That Supreme Court upheld. But the entire construct of the arguments before the Supreme Court is that it is steeped in culture. In Tamil Nadu, my lord, because of Jallikattu, and in Karnataka, my lord, because of Kambala. The question was, where are you conducting these sports? The sports are being conducted only in two places, Dakshina Kannada and Udupi, no other district. It was not the case of the government, my lord, that we are going to conduct it throughout the state. Now, emboldened by that, you cannot start a process of then starting it in different parts of the state. And for this, my lord, in my respectful submission, animals have to be brought down from there. Over 300 kilometers of journey, those animals will be put through in trucks, herded in.
So what is your submission?
Well, my submission is, while we can't object today for the sport being held in Uttar Kannada and Dakshina Kannada, I'm sorry, in Dakshina Kannada and Udupi districts, it cannot be held everywhere else in the state. Because it is part of the culture only of that area. And is part of the culture only of that place.
For we are asking that whether Supreme Court has said.
Supreme Court has not said it, Lord. Supreme Court did not go into which part of the state you can do it. That was a statement which came from the state itself saying it is part of the culture of that particular area. Supreme Court has not said it. Lord. If Supreme Court had said it, this would be contempt. What they would have done would have been contempt.
So you cannot argue that the holding of event amounts to cruelty.
Lord, holding of event in this particular scenario will amount to cruelty. I'll tell you Lord, why I'm
This
saying.
is what we want. That proposition we want.
Yes, my Lord. I'll tell you, that is exactly what I'm saying, my Lord, now. Because these animals, my Lord, now have to be.
Because generally the Supreme Court has said that holding of events, provided the provisions are complied with, will not amount to exerting any cruelty on the bullocks or the animals involved.
Yes.
And your submission is that
I know. These bullocks, my Lord, are brought from Dakshin Kannada or Udupi. They travel 300 kilometers by trucks, are brought in here, and then they are made to race. Now, this becomes a commercial event. It is no longer traditional.
it is like that somebody has to go to CS to purchase a ticket.
Yes, yes. Purchase tickets. There are food courts. There are, my Lord, 2,200 VVIP stands, seats. There are hundreds, lakh of people expected to come for such events. Last year, they said they are bringing 7 to 8 lakh people. Lots of people see it had sponsored. It was a sponsored event. There were sponsors who had put money to organize the entire show. It can't be a show, my Lord. It has to be a traditional function which is there as part of the culture of the particular area. It cannot be conducted into, it cannot be converted into some kind of a commercial activity now. And last time, my Lord, we have conducted a study as to how it was done in Bangalore because we couldn't file a petition in time.
Now this amendment is post, it is when inserted.
Yes, madam. This is inserted after this was the challenge before the Supreme Court.
So this Nagaraja.
After Nagaraja. After Nagaraja, to cure Nagaraja, or the defect that they found in Nagaraja, cure it, this amendment was brought about. And that was upheld by the Supreme Court in 23.
My lord, may I make one submission, my lord?
Let us see. It is not.
My lord, legal contentions are
We have
being
not
urged.
completed hearing, Mr. Chinnappa.
No, my lord, my lord, legal contentions are being urged.
We will hear you only after Mr. Chinnappa concludes.
My lord,
Our
the-
permission.
My
We are
lord,
still- we are
my
still
lord,
hearing.
I'm taking the liberty. Learned Advocate General will be appearing. My lord may have this day after. My lord, legal contentions are being urged.
Reminding only Advocate General will forget every argument.
My lord, legal contentions are being
The
urged.
middle of
Let me
the,
complete,
middle
madam.
of the hearing, you are reminding. us.
No, my lord, in the beginning itself, I tried to, my lord, make a submission, but my lord
But-
wanted to hear.
Complete, my lord.
Let it come.
It's
My
all
lord,
not
legal contentions, my lord.
We are trying to understand. If we understand them, we will be able to understand Advocate General.
No, the Learned Advocate General will be able to meet these contentions.
We will go and remind, yes, where is he, but
My lord, he's in Delhi. My lord, he's coming back this evening.
I
That's
see.
why at the beginning itself, I tried to move, but
when the event is going to be held?
26th, Sunday.
26.
Yes.
my lord may have this day after. My lord, he's coming today. Then tomorrow he can take instruction. 2:30 tomorrow, my lord may have this. I'm not asking for a long adjournment.
Since we've
Because these are all legal contentions, my lord, being
This-
urged. I don't know what
be-
instruction the Learned Advocate General will be getting from the government. My lord, because as far as I know, no invitations have been issued so far for the event to be held on 26th. The district committee has just decided to hold.
My lord, anyway, I'll complete my submissions. My learned AG can respond whenever before 26th. Yes, sir. And now, my lord, the difficulties, they'll start bringing the animals here.
Will not hear the argument, will complete the submission on facts.
Yes.
Very
Factual
well.
aspect. Then we'll see what.
I'm obliged, I'm obliged.
I'll just show your lordship the other amendments which have been made to this act. Please see, my lord, section 11 now.
Page
Section 11 of the act.
11.
The amendment to section 11, my lord. Lordships will see what section 11 is. 11 is treating animals cruelly. That's the heading of the section. Now, if my lord kindly comes to section 11, 3F, which is an exception section. 11, 3, subsection 3F.
The F, yes.
F. My lord will kindly see the language, my lord, how it starts. Nothing in the section shall apply. Nothing in the section shall apply to F. The conduct of Kambala with a view to follow and promote. Please see the language, my lord. With a view to follow and promote tradition and culture and ensure preservation of native breed of buffaloes as also their safety, security and well-being. Again, Lord, the languages to.
So according to you, two aspects.
Yes.
Promote tradition and culture and ensure preservation of the native breed of them.
Native breed and their safety, security and well-being, all three.
But these buffaloes are of native breed means those areas?
Those areas. Those areas.
That is what your submission.
That is my submission. And they are now being brought to Bangalore only for the purpose of running. Now, the next provision, your lordship may kindly see.
Anyway, we will not go further on merit because they are seeking.
Lord, my only concern is now those buffaloes have to be brought into Karnataka. I'm sorry, to Bangalore. Now, if all that process starts.
When Advocate General will be able to argue?
My lord, tomorrow or day after, if my lord.
Tomorrow 2:30 then.
Yes.
Because the We don't know where the matter will go, which way, even for any order. But either way it goes, it will be.
No, I
the
understand.
Time will be again running against for you and for them both. That is the whole. We have no other.
My Lord, I'm informed that he has one matter at 2:30 tomorrow, my Lord, that with regard to that Karnataka scheduled caste and scheduled tribes matter, it's a date given matter. Day after, no, it's before the other court. If my Lord would have it on Thursday, very well, I leave it to my Lord. I brought it.
Tomorrow at 2:30.
Yes. Yes.
My Lord, I apologize, my Lord.
Lord, I hope, my Lord, that the committee will not now take steps to start the process of bringing the animals into Bangalore. At least let them not do it until your lordships decide this question.
What?
The animals, my lord, have to be put in trucks, and from the Udupi or Dakshin Kannada have to be brought by trucks to Bangalore. That itself is cruelty.
But then it will amount to granting stay at this stage without hearing the other.
No, I'm only saying
We don't know what we will do.
No, no.
And we don't want to express anything about even bringing of the bills because not knowing the result ourselves, how can we pass any?
I'm only saying, Lord, that too. They shouldn't come tomorrow and say, we've already brought the bullocks into Bangalore, so let us hold the event. That
My
I
Lord,
can't put it beyond
invitation
them.
cards themselves have not been printed and circulated.
What is the, how much it takes from bringing Udupi?
It's 300 kilometers.
6 hours.
8 hours. 6 to,
8 hours.
Animals means 10 hours. My lord. Trucks will have to come slowly. It's so long and not a small number. I think about 200 animals will be brought in.
We do not know what to do. It is for them and you to take a call. Only since they are seeking time, we are at them.
Yes, my Lord, tomorrow, 2:30.
Nothing more today.
Very well, madam.
I'm obliged, my Lord.
Shall I record that? While the present public interest petition proceeded with the submissions of learned senior counsels for the petitioner, in course of the submissions, it was requested on behalf of the state by learned additional government advocate, Ms. Nilofer Akbar, that since learned advocate general is appearing and that since he is not available, the hearing may be adjourned, full stop. Acceding to the request, stand over to 23rd or 20?
Yes, 23rd, my Lord.
Tomorrow.
23rd of October 2024.
Obliged.
2:30.
We'll take.
Yes.
Without recording, we'll take.
Very well. If morning is possible also, then we'll try morning.
Yes, my Lord, I'll inform him, my Lord.
Yes. Great.
If morning, it's better because
It's fresh.
we are fresh there.
Yeah.
We'll keep the same way. And
Number 12. From Neglur Arvind, PA.
There was a bus shelter at a busy bus stop in Hubballi. It was serving hundreds of commuters. All of a sudden, somewhere during January or February, it was unauthorizedly removed. P, C, D, and E are my representations. Now, sixth respondent visited the spot and found out that there was a bus shelter, in fact, and it has been removed. And sixth respondent feels that there should be a bus shelter there.
so bus shelter you want to install.
I want it to be re-erected where it was earlier.
Third learned advocate. Mr. So and so, sorry for the petitioner and learned additional government advocate.
It was serving for 10 years, 10 long years. It was abruptly removed for the benefit of a commercial complex owner.
We will install bus shelter. High Court? Is a subject matter to be brought before the High Court?
My representation,
Installation of bus shelter.
my representations have gone unheard.
You are reducing the jurisdiction to what extent? Sorry, we're not inclined at all. Are you inviting order? Or withdrawing?
I may be permitted to pursue the matter with authorities.
So and so, in course of the submission, seeks permission to withdraw the present petition, stating further that the petitioner would opt to pursue the representation already made before the authorities in relation to the grievance and the prayer made in this petition, without a paragraph expressing any opinion merits and without going into merits. The petitioner is permitted to pursue the representation. The authority shall take a decision within 10 weeks in accordance with you.
Very well.
Obligement.
Seal number 13.
Here for the petitioner. This matter pertained to unauthorized hoardings and illegal flex banner. 12th August, your lordship has passed an order wherein they framed the rules.
This is only to know, Is there any distinction between flexes and hoardings? Flexes are small, hoardings are big. No.
It's more like a terminology difference. Flex is a material which is being used.
Flex is a material.
It's a material. And hoardings are anything which can be hard or hard substance,
They have like.
including electronic melts.
So some guidelines for
Writing.
Some guidelines for to be.
Now yes, please, my lords, the bylaws, my lords, last date we had submitted draft bylaws were issued and objections were called for. And my lords had also directed the petitioners to submit their objections. Objections have been filed by various people, my lords, including petitioners. Now the BBMP has forwarded it to the state is my instructions. We need to finally notify it after correcting and incorporating all this. My lords, they have requested for 3 weeks accommodation for final notification.
We have submitted our suggestions, your lordship.
Objections have been submitted by them also.
Around
It's been considered and we will send it. to the
various
government.
objections.
Let them
have been-
consider our suggestions which are filed along with the. Because we are not opposing the bylaws or whatever. We are given suggestions as passed by the Tamil Court on 12th August. So let them look into it and then they can finalize it before it's
Let it
being
be sent
finalized.
to the government.
We can
Manoj,
audit.
We will look into it and we'll.
We'll have to look into it.
My
Today
lords,
is what date? Today is,
today is 22nd, my lords, 22nd,
so we'll keep on 20th November.
please.
My lords, if I may be permitted, my lords. Yes, yes.
13.2.
My
And
lords,
one more submission,
Not
lordship.
spoken about anything about the taxes, my lord.
Yesterday, Bangalore Mirror has written an article in Skywalk in Majestic area. Huge hoardings have been put up, flex banners. And also that Skywalk itself is in danger. It may fall any moment because they want to dismantle it. In 2022 itself, BBMP has passed an order. Till date, no steps have been taken. Repeat, these hoardings, huge hoardings falls. Bangalore Mirror yesterday they have given They have to look into it and because like this, several places are happening. Because earlier lot occasion when I made a submission, we are happy that some control is. Now again, it has gone out of control for all the festival wishing birthday.
Whatever you want to
Yes.
say, make part of pleading
Yes,
so
sir.
that it can dealt with,
Yes.
not orally.
Yes.
Correct?
My
The
lords, in
suggestion
the-
is given
in
on
the
21st
compliance
August.
affidavit, they have not uttered anything about the taxes, my lord. It
About
was about the
taxes.
taxes, my lord. It was
Regarding-
instructed.
Regarding taxes, my lord,
Present petition came up for consideration today. Learned Additional Advocate General Ms. Pratima Honnapura stated that which notifications?
Please draft Brihat Bengaluru Mahanagara Palike Advertisement Bylaws 2024.
Get the name. Give the name.
Please, I'll give it.
Are at the stage of consideration of the objections,
Please,
which are already submitted by the stakeholders, including the petitioner.
by general public also.
She further stated that the notification shall be brought into force once the
Objections are
same
considered.
are approved by the state government.
Please.
Full stop. Having noted the above submission and the aspect, comma, the petition shall next come up. It is ordered that the petition shall come up next for further consideration on 20th November. Of November. Since the court is seized with the subject matter of the present public interest litigation relating to the monitoring and regulation of the hoardings practices which are being put up. The city of Bengaluru, whom it is directed that the aforesaid notifications, aforesaid regulations shall not be notified without first being produced on the record of the present proceedings and approved by the court.
13.3, my lord. This is with regard to LED signage boards. That's all with regard to the flex advertising boards. This is a LED signboard where there is a.
So to be segregated,
Last time your lordship has
you segregate it?
it is better to segregate it because it is a, when the flex boards are abolished, they came into this type of the LED signage boards. Now in all the area,
Correct. We'll see while we'll further considering. At that stage, we'll segregate. Let it be here together.
In fact, under RTA reply, the BBMP has given they are not permitted any LED advertisements on private property. That is the reply.
they
I
are
have filed that memo also and complaint also is given. It is not permissible under law. They are not given any permission also. This reply, where Ash may kindly see, the RTA reply this.
Place on record, whatever you want.
Because why happening now this board illegal balance everything has been now banned to some extent interest of court. Now they are all shipped over to LED, which is more dangerous and traffic hazard.
They're not dealing with
That's
any
right.
method.
That also a larger complaint, please.
Grateful.
Yes.
Observed and provided that if in the interregnum, before the petition comes up for consideration on the next date, any hoarding or flex is installed and found to be endangering the public life, it will be open for the petitioners to place on record the details of such details.
Number 14, Sumoto PA.
Lord, I appear as amicus in this matter, my lord.
I appear for the government, my lord. My lord, last date of hearing when I filed a report, my lord, there were certain shortcomings that were noticed by my lords. And my lords had directed me to file another report rectifying the shortcomings. Lord, the report is ready. I will file it in the office, my lord.
Learned additional government advocate, Ms. Srimati Liloparak stated that she will file report within a week as earlier directed by the court. Stand over to
My lord, may I make one short submission, my lord?
14th of November.
Obliged, my lord.
May I make one short submission, my lord?
Yes, yes.
Your lordships had given specific directions on the last day. There's one aspect which I noticed, my lord, that the main issue here happens to be first and foremost filling up of the posts of senior warden and junior warden, because otherwise these will be headless institutions. Now, in respect of this, one of the clear submissions made in the report is that matters are pending before the finance department, my lords. From my limited understanding, my lords, quite often, many of the policy proposals get scuttled at the finance secretary level, my lords. If your lordships considers it appropriate, my lords, the finance secretary also may be additionally made a party, my lords.
So there are already a direction, you will be responding to it.
Yes, my lord, but he wants the finance secretary to be
Yes,
made a
my lord.
party, my lord, so that, my lord, the finance secretary will be able to inform, my lord, the
Because
reasons why.
yes.
No, state is there or not?
State is there, my lord, but the finance secretary.
Finance department, my lord.
Mr.
Additionally,
Council, once the state is there, it includes everything.
my lords, that is true, my lords. What happens is that in terms of clearance of this, all posts will have financial implications. Therefore, the objections may come at that level, my lords. For better coordination, it's my humble suggestion, my lords. In that event, even the finance department will file its affidavit, which would be helpful, because it's not only a policy decision, but also a financial decision.
Then you join the finance department
Yes, my lords. Finance secretary can separately be made additionally party,
in the beginning.
because the finance also will be filing the.
At the threshold of the hearing of this petition today, from a learned senior advocate from so and so, seeks permission of the court to implead the state of Gujarat through the Secretary Finance Department as party respondent. Full stop. Permission is granted. The amendments will be carried out forthwith. Full stop. Registration shall issue notice to the newly elected party. Full stop. New party returnable on 14th November. Full stop. Learned additional government advocate Srimati Liloparak accepts notice.
Yes, ma'am.
On behalf of the newly elected party, then the order which is passed.
Grateful, great.
Number 15. Please, Lord. Shyam Kumar SU.
My lord, in this additional affidavit of the chief secretary has already been filed in the office. If my lord could have this on Monday, my lord, additional, learned advocate general will be appearing in the matter.
My lord, your lordship has passed a peremptory order a month back.
Very well, my lord may have this on
And
Friday, no problem.
Thereafter.
Friday.
Third day it is coming, my lord.
Friday, no, not Friday, Monday.
Obliged.
Or it
Monday,
can
what
be
date?
Monday at 2:30 will proceed. File whatever you want to.
We filed, my lord. Only he has to be present to make a submission.
28th of October.
My lord, this is the third time they are.
We are aware, but
No, we filed. It's only the learned
and
advocate general. who has
the
been-
subject matter is very important.
No, right, ma'am. Yeah, yeah, yes, my lord.
So we'll proceed on Monday with hearing.
When, yes, my lord.
28
Yes.
March.
Yes. Green bench matter, still number 16. Okay, Vaishali Agde.
For the first question. 16, my lords, this is the
My
matter
lord,
which.
this also a short accommodation. my
Because
lord.
the Advocate General appeared last.
I know. Maybe day after tomorrow.
Anything is worked out?
My lords, they are only issuing further demand notices.
Further,
We have said at least,
Then
anyway, I can't start, my lords, but day after tomorrow.
if there are dues, then they are bound to issue demand notice.
My lords, it got adjourned. Now, my lords, whatever we argue here, that they include and issue. Anyway, day after tomorrow or something, there is some urgency, my lords. Now, what's the problem is my entire unit is closed. IBM has revoked the suspension order. They say, pay the royalty and get it cleared. Now, this is the only issue now.
5th November.
My lords, my cement plant is closed. 1.8 crores per day I am suffering loss.
Him. You have to do it.
Please, day after tomorrow.
That is what last time it was suggested. Anyway. 25th.
Please.
Obliged.
Please. Sorry, I'm pressing, my lord, but there is some. That's all.
Lord, I'm very sorry to say, my lord, 28, I have two matters. Can it be 29th, my lord?
29th. So then why not 4th? 4th.
29th?
4th.
No, 4th, no, my lord, I'm in Delhi.
All right, 29th.
Obliged.
Much of time. Thank you.
So writ appeal matters, still number 17. Mr. Som Sundar Rao. Mr. Som Sundar Rao, 17.
Sixth November.
Number 18. Mr. Abhijit Arnaldi.
Upperland.
Lord, this is allotment of sites. plots by the APMC, Agricultural Produce Marketing Committee. I applied for one plot. Respondent applied for about 13 plots. Then in the proceedings, my lord, it was finalized to provide one allotment in my favor. The APMC called for objections. He did not file objections. Since he did not file objection, the allotment was finalized. Now he is not a person who claimed allotment for this site only. He made application for about 13 sites. Learned single judge, my lord, has set aside the allotment made in my favor, for which lease cum sale agreement also has been executed, and has directed, my lord, that this site should be given to him and I should be given an alternate site. Whereas when this was finalized, objections were called for, he did not file any objections.
So what is the submission? What is the case?
Lord, both of us, Lord, the appellant and the respondent, sought for allotment of sites by the APMC. The respondent made an application for allotment of about 13 plots. I made an application for allotment of one plot. The APMC decided to give me one plot, that is A16, in my favor. After finalizing this, they called for objections. If anyone has objection, they can submit their objection. No objection was filed by the present respondent, writ petitioner. Thereafter, it is finalized. After the finalization of allotment, he comes to the court saying that he should have been given the plot which was given in my favor, for which lease cum sale agreement also has been executed by the APMC. And it is not one site he makes an application. He makes an application for about 13 plots. 13 different plots. So the APMC can give many other plot. But the question is, now the learned single judge says that the allotment made in my favor has to be cancelled, and that should be given in his favor. Whereas his application is not in respect of this particular site. He makes, and his application is for about 13 different plots. In fact, his application, my lord, your lordship would get it at page 70. In fact, at para 9 of the order, the learned judge says that he has indicated preference for A16, which is not correct, factually incorrect. Para 9 of the judgment, page 22.
But respondent petitioner was, as per the finding of the single judge, was senior in terms of the
Para 9 of the judgment.
para 9 of
Please.
But that is not correct. His application is for about 13 sites. He does not indicate preference for this site at all.
You demonstrate that you were entitled to in terms of seniority.
No, seniority, my lord, not for this particular site. In the seniority list, it was finalized, and that seniority list was published. Kindly see, my lord, that the paper publication calling for objection at page 140. Finalizing this list, and if anybody is aggrieved, they can file objections before 9/4/21, page 142. Last four lines in page 142, objection suggestion in this regard shall be submitted along with necessary documents in the meeting scheduled on Friday, 9/4/21 at 11:30 a.m. in the committee hall. Objection suggestion received after lapse of time will not be entertained. Now he files the objection. This is dated 30/3/21. He files objection after 4 months, after everything is finalized at 103. Page 103 is his objection filed on 19/7/21. After the finalization is done on 36/21 at page 161. And the learned single judge holds that he did not have opportunity to file objection, which is also incorrect. At para 7, and in fact, by that time, the lease cum sale deed also had been executed on 9/8/21 itself. And he has been also allotted another site also. It is not as if no allotment has been made in his favor. He has also been allotted and I have also been allotted. He has been given the site number C31 has been allotted to him. And when he makes an application for 13 sites, it does not say that it is only making application for this particular site. Seniority will only arise when there are two applications for the same site. At page 120, the
No,
allotment. made.
specific sites were required to be applied for.
Pardon, my lord?
Specific site
Yes.
indicating numbers were required to be applied. for.
Yes,
So
on by the seniority list.
petitioner applied for which site?
My lord, the petitioner has applied for site number 16, my lord.
Page,
Page 101.
page,
Page 101.
A16 was applied for.
page, where do we get it?
Page 101, my lord.
102,
101, and
101.
translated in Annex D, page 103.
No, that is their objection.
No, it is not objection. It is an application.
No, this is the,
It is an application.
101.
101.
our objection, their objection. Annapurna is the respondent, they have filed their objection.
The appellant had not made an application for the site, which was granted.
No, you are for original petitioner.
Yes.
Annapurna. So we want to know your application. It is page 102,
Yes,
103,
103.
translated.
Yes.
No, this is his objection, my lord. His application is at page 70.
So
A16.
A16.
A16 is not the one, my lord. He kindly see his
A16
application.
was allotted to the appellant now.
Kindly see page
That was
70.
not modified and by.
But the learner single just says 16.
A16.
A16 is allotted. To him also, my lord, C 30 is allotted. At page 120. Which he did not object. At page 120 is the allotment. Page 71 is his application.
Seniority is determined in what basis?
Mine is 12. His is 36.
That is, my lord, according to the rules, Rule 8
Rule 8.
deals with the total turnover
It's a
in
total
respect of the
term,
market
not the
fee
date of
paid.
application.
Allotment of property in market yard rules. In the APMC.
Date of application is the basis for determining seniority.
Now, what it says is, my lord, date is not relevant. What they say is, how much market fee is paid during previous 3 years, average market fee paid. On that basis, the seniority is determined.
So he says that in terms of that criteria, he was senior.
No, he is senior for which site, my lord? No, he makes an application for 13 sites. Now, kindly see page 70.
No,
He makes an application,
Rule 8 contemplates which site criteria? Or it contemplates only the turnover criteria?
Rule 8 only deals with this turnover with regard to market fee paid, my lord. On that basis, seniority is determined. But I made an application for only one site. He makes an application for 13 sites. When it is finalized also, he does not file objection. He does not also seek for allotment of other sites which he has made an application. He has also been allotted a site and I have also been allotted a site. And in my case, my lord, this after the entire thing is finalized, they file objections after this. Learned single judge holds that he did not have opportunity to file objection at all. Rule 8 of this allotment of property deals with the principle for selection. That seniority should be determined with reference to the particular site which is applied for.
Even site vacant. Site ಯಾವ್ದು ಇಲ್ಲ, vacant ಯಾವ್ದು ಇಲ್ಲ. So is it anywhere provided that how to deal with the multiple applications by one?
My lord, respondent number 3 before your lordship is the committee of APMC, my lord. Notice have to be issued, my lord. They are represented by a panel council. I would
They're
accept
asking-
notice on behalf of respondent number.
They're
2, my lord.
asking you, Mr. Council,
Please, my lord,
is there any mechanism
please.
to deal with the situation where multiple number of sites are applied by one party?
At a certain, my lord.
That is not, that
this
is the
is the-
point.
That's the point.
That is the point.
That's the,
This shortlisting, preparation of seniority is done by the respondent number 3, my lord. The APMC committee, my lord. They have to be notified in the matter, my lord. Based on their proposal, my lord, the government accepts it, my lord.
and further what? And further what? If I apply for 2 sites,
Please.
of a party applies for 2 sites, both will be given to him.
My lord, it is, my lord, in this case, my lord, is
So what is that?
Only one side.
one
only
side
one
will
side
be
has to
allotted,
be-
my lord.
You have to choose the one side, either one.
You have to choose one side.
One side.
He applies for 13 sites.
So is it applied in order? 13 sites in order of preference?
No, it's not in order. Page
Preference-
71.
preference Sides.
He chooses different sites, 180T, 296A.
But before approval, my lord, the single site was offered. Single site was offered.
Only single site only.
It was offered to you.
Yes,
16A was offered.
16A was offered.
16,
Offered.
no, 16A is not offered. He was given C 31 at page
D is
120.
the- Annexure D is the,
Page 120, A 16 was given to me. He was given C 31 in the same block,
but the question is, my lord,
page
the,
120. Page 120.
120.
120, Annapurna Enterprises is my learned friend. He has been given C 31 in A block. I have been given A 16 in A block 1. For which they did not object. It is only after the entire thing, lease cum sale deed was executed, thereafter they woken up.
for 31.
And kindly see, my lord, page 71 is application.
So this page 119 is what? The translation of what? Some order.
That is the allotment made by the,
Then what made the authorities to change this allotment? On what basis this allotment was changed?
my lord, they have, my lord, on the basis of the proceedings, see, they prepared a seniority list according to which they called for objection, which your lordship would get it, my lord, at page 98. Only extracted, the relevant portion is extracted. The seniority list is prepared. In that, my lord, the application of the present respondent is at page 100. Reference is given to sites which he has sought for. On the basis of this list, proceedings takes place at page 161. At page 100, it indicates about 13 sites he has applied. At page 161, my lord, they called for objection before finalized. No objections were filed. Thereafter, it is finalized at page 161. Each objection has been separately considered in the proceeding. At page 175 is the allotment, proceedings of allotment. Page 161, it starts. Whatever objections are filed is considered in detail. since there was no objection for this particular site, the allotment is made at 175. C31 is allotted, A16 is allotted to me.
So you want to solve number 3?
Please, my lord.
The number 3 is the authority concerned.
Yes. The committee, my lord, which have prepared the seniority list.
Or learned senior advocate Mr. So and so, assisted by learned and so and so for the appellant, learned additional government advocate. Mr. So and so, responding state and learned advocate Mr. So and so for respondent one original petitioner. Notice returnable on 13th November. Learned notice shall be required to be served only on this one 3, since for the other respondents, number 1 and 2, respective learned advocates accept the notice.
The least concerned deed is already executed in my favor, my lord. The order of the learned single judge is to cancel that allotment. A request for a stay order.
Stay can be granted. The amount to having the petition.
No, because now the least
can say that-
concerned is already executed.
Status quo shall be maintained by all the sides
Yes.
in relation to the site in question.
Yes.
Sites in question.
Bill number 19, to Shrikant MP.
For appellate, my lords, an employee of needed educational institution, my lords, initially preferred a revision petition before the authority, my lords, who
There is
passed
a
an
delay.
order saying that he should be paid the salary as
There is
being
a-
paid to other employees.
Delay of 71 days.
Yes,
not
please. Please.
21st of October, November.
And number 20. XM Joseph.
Please, my lords. Your lordship will kindly see page 10 of the paper book. Please, my lords. What was in challenge before the learned single judge was the entries made in the routine orders contrary to records on the records before the court. Now kindly come to page 10, my lords, the pen of paper book. Page 10.
10.
10 of the paper book. Yes. Subpara 5. Whether the daily routine orders of the learned magistrate, such as adjourned, call on by, filings by parties, last chance, heard, posted for orders, which are entered contrary to records, and those are purely to carry out basic proceedings with no effect of adjudication. Now, if the answer to that question is in the affirmative, it amounts to conferring DRT with a supervisory jurisdiction over the magistrate's court. Now, your lordship will kindly see the prayers that were made in my writ petition. Prayers that were made in my writ petition, which is extracted at page 2 of the impugned order. If I had challenged the final order of section 14, I could have been relegated to the alternative remedy of appeal. What was challenged is the recordings, daily routine orders, which are all contrary to the records. The certified copies of those records are also before the court. Your lordship will kindly see, my lords, during pendency of the earlier writ petition, at page 50, my lords, 50. Issues which were pending in my earlier writ petition, pending determination was, when does the right to securitization accrue to the secured creditor? Is it under section 21J or under 21O?
What is page 82?
Page?
Page 79.
82 is, 82 is, balance. Unless I bring it to the notice of the learned magistrate at page 50. I'm sorry. 55. The Lordship will kindly see page 55. Page 55, my lords.
25.
Page 55. I bring it to the notice of the learned magistrate, 55. The pendency of this determination of these questions in writ petition number in my earlier writ petition. Now, if your Lordship will kindly see para 4 at page 56. Demand notice being a foundation for seeking magisterial assistance. The demand notice in the present case, which is placed by the applicant petitioner before this honorable court itself, is under challenge as to its validity in the above mentioned writ petition and is therefore a matter in res subjudice. Now, thus, while foundation of the grant of magisterial assistance under section 14 of Surface Act is the proviso 5 to the said section, and the validity of said proviso is in challenge, the honorable court shall not frustrate the proceedings which is thus pending before the honorable court, more so in the light of the ratio contained in D. Kathirivedi and Sons report in 86, supplement SCC 20 at para. Now, my lords, this is a certified copy of the application which I have filed. This application does not find a place in the order sheet. It is received by the learned magistrate. Learned magistrate's initials could be found at page 55. I have obtained a certified copy. The certified copy is this document. This does not find a place in the order sheet. Now, the Lordship will kindly come to page 88. This is the written clarifications which was written clarifications were sought by the learned magistrate. I filed the written clarifications. Now, if your Lordship will kindly come to page 62, the order sheet. What is it that is written?
Expand the recordings on 29, NXFD. Where is that NXFD?
Page 88, I filed written clarifications. At page 65, page 62 onwards is the order sheet of the magistrate's court. At page 65, memo file seeking for 3 weeks' time. I never sought for 3 weeks' time. It is the written clarifications which I filed. Now coming to, my lords, the proceedings dated 20th April 2024. The Lordship will kindly see the proceedings dated 20th April 24 at page 66. The proceedings of 20th April reads as, respondent absent, no representation, representation appears to be interpolated, postal cover received from respondent, alleging that mischievous memos have been filed. Now, that memo is also before this honorable court at page 94. I have not made any allegations.
It's already passed in which proceedings? It's 7. Section 14, secretary.
Irregularities which was assailed in the writ petition. Now, the learned single judge asked me to go and challenge all this before the learned DRT. That means conferring DRT with supervisory jurisdiction.
Anybody appears? You are appeal? Not appeal.
It's Canara Bank. It's Canara Bank.
Bank is the party.
Not appeal.
Canara Bank.
Hard learned advocate, Mr. Sorry, Mr. So and so for the petitioners. Paragraph invoking the jurisdiction of this court under Article 226 of the Constitution. The petitioners have made prayers in two folds. First part of the prayer is to set aside and or expunge the recordings on 29/12/23, 8/2/24, and 26/2/24. Into bracket produced, copy produced at NSRD, Bragator, recorded by learned 10th Additional Chief Metropolitan Magistrate, Bangalore, in criminal basis application number 50231 of 2023 as incorrect and arbitrary. The second limb of the prayer is to set aside and expunge, set aside and oblique or expunge. Recording dated 28/4/24 by the same court in the very proceedings, in which the expression in mischievous memos or is employed. The aforesaid proceedings of criminal message application number 5023/21 are under the provisions of the Surface Act, full name, 2002. They are in relation to the petitioners, the husband and wife, who have taken housing loan for purchase of house, be as it may. Paragraph. It appears that in the said proceedings, certain miscellaneous observations miscellaneous orders endorsements came to be passed by a learned judge while adjourning the case proceedings from time to time. The order sheet is produced. Full stop. It is true that paragraph, the word malicious or mischievous memos, but both, etc., are used by a single judge. Also, the court is of the view that a judicial officer should desist and dissuade himself or herself from using indiscriminate language in the judicial orders. Paragraph. Apart above, no rights accrue for the petitioner to get the same set aside inasmuch as they are the miscellaneous observations of orders of endorsement, which does not pass in the course of the proceedings, which does not decide any of the rights of the parties and does not reflect on the rights of the parties. The prayers in the nature made and advanced in the petition could hardly be granted. Furthermore, the record suggests that the court has the Court of Learned Chief Metropolitan Magistrate has already passed a final order under section 14 of the Surface Act, allowing the petition of the petitioner Canara Bank as respondent herein, directing to take over possession of the property from the appellants herein. Paragraph. In the above context, paragraph, learned single judge, while dismissing the writ petition, has rightly observed that the petitioners have alternative statutory efficacious remedy under section 17 of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002. Surface Act 2002. Therefore, learned single judge has
I'm sorry for the interruption, Manoj.
not entertained the petition without
My
expressing any
interrupt-
opinion merits and reserving liberty for the petitioners to approach the debt recovery tribunal under section 17 of the SRPC Act. Full stop. The court had also directed the petitioner to deposit a sum of rupees 1 crore, out of which 60,000 came to be deposited by the petitioner. The remaining balance, it is observed by learned single judge, shall be paid by the petitioner within 2 weeks, and that the interim order passed on 27/5/22 is directed to continue for further period of 3 weeks. Full stop. No error could be booked, paragraph, in the order of learned single judge disposing of the petition, reserving liberty for the petitioners to approach the debt recovery tribunal by exhausting the alternate remedy. Full stop. The challenge is meritless. The appeal is dismissed.
That's serial number 32, my lords, with the leave of the court. The matter is pending before the apex court. Order also. Afternoon, I got some inconvenience, but the position to attend the matter, sir, just passing the order of the honorable apex court order, my lords.
You on
Matter
time?
needs to be adjourned. Please, ma'am.
You on time?
Please.
Which date?
And after the month of December, my lords, because today the matter is,
It was stated by learned review. Which number?
the matter is pending
Serial
before the
number.
honorable apex.
Serial number
32, my
32. It was stated by learned advocate Miss
Sinchala.
for the appellant that the subject of these proceedings is already pending before the Honorable Supreme Court. In that use, she prayed for time. She prayed for longer time. Stand over to 13th December.
Please.
Lord, serial number 34 also, my lord.
Hello, court officer? Court officer? Court officer?
Court officer? Hello, ma'am. Hello.
நம்ம வந்து டென்ஷன் மைக் பண்ணி பாரு. சும்மா இருக்க வேண்டியது. மைக் பண்ணி பாரு.
ரெக்கார்ட் பண்ணிருக்கியா?
கிட்டத்தட்ட ஒரு 5 நிமிஷம் நான் வந்து நெஞ்சு ஏங்கிக்குது. நல்லா நோட் பண்றேன். என்னென்ன இது ஏது. அப்ப வந்து அஜித் நம்ம இடத்துல. கடைசி நேரத்துல மட்டும் நாங்க
என்ன மாதிரி? என்னப்பா கையில வர மாட்டேங்குது.
சிக்கன் விளையாடுவாங்க, மட்டன் விளையாடுவாங்க. விளையாடுதான். ரெண்டு ஆடு வந்து கறி ப்ரோ. ஆமா. சிக்கன். சிக்கன் தான் தெரியல. சிக்கன் ஏதாவது சொன்னாங்க. பேர் எதுவும் சொன்னோம்.
ஸ்ரீராம்
பண்ணக்கூட.
பேட்மிண்டன் ஆடுவியா? நல்லா ஆடுவியா? சரி நம்ம பேட்மிண்டன் ஆடலாமா? வீக்லி ஒன்ஸ்
எங்க போவோம்?
பேட்மிண்டன் போட்டே போலாம்.
நான் கோட்டை என் வீட்டு பக்கத்துல ஒரு
நாட்டு 300 rupees.
ஆமா.
ஓகேவா?
ஆ.
நம்ம 4 பேர் போனோம்னா மாத்தி மாத்தி அடிக்கலாம். நம்ம 2 hours
டபுள் சார் தானே?
அதுதான் சொல்றேன்.
டபுள் அடிக்கலாம்.
டபுள்ஸ் அடிக்கலாம். அந்த மாதிரி 4 பேர் போனா டபுள்ஸ் அடிக்கலாம்.
கேட்ட போமா?
அதுக்கு வேற யாரு?
நாரடி.
எந்த இடத்துல இருக்கும்?
எனக்கு டி நகர்ல வீடு பக்கத்துலயே இருக்கு எனக்கு. ரெண்டு கோட்டம் கோட்டம்.
எவ்வளோ?
டர்ஃப் கோட்டும் இருக்கு, உனக்கு வுட் கோட்டும் இருக்கு. எனக்கு வுட் கோட் வந்து
எவ்வளவு வருது ரேட்டு?
எனக்கு 400 போட்டோம். இந்த இதுதான் இந்த
Mr. Sriram, please. இல்ல ஆனா எல்லா சாட்டே போக மாட்டேல்ல. You have to mute yourself, sir. The audio is unmuted.
The passover matter, seal number 6. Mr. Murali Krishna Brahmanandam, party in person. Seal number 6.
Party in person was absent in both the calls, in the first half as well as in the second session. Full stop. Instead of dismissing the petition for want of prosecution, in the larger interest of justice, stand over to 28th of November. Make it 22nd November.
Yes. Seal number 10. Mr. Chekki Siddhavir.
I beg to appear for the petitioner in this case, my lords. My apologies, my lords, in the first session I could not appear. My lords, this writ petition is filed seeking the writ of mandamus in this honorable court to consider my representation produced at Annexure C1, my lords. Annexure C1 is dated 11th March 2024. That has been given to the respondents to consider my representation to start the repair works and initiate irrigation project, my lords, which is and my lords, the respondent number 1 already has undertaken the lift irrigation project, my lords, with the cost of 13 lakhs 90,000, my lords. And this cost has been approved by the respondents, my lords. Prior to this representation, my lords, I have made a representation and which has not fruitful, my lords. The representation is dated 31st January 2018, which has not yielded any constructive results despite my earlier representation, my lords. Therefore, I am before your lordship to consider my representation and start the irrigation project, my lords.
So we are sorry. Heard learned advocate so and so over the petitioner. The petitioner, who claims to be a public spirited person and a social worker, has filed this petition in the nature of public interest petition. The prayer made is what is prayed is to direct respondent number 1. State of Karnataka, there's minor irrigation and groundwater development department to restart the lift irrigation project situated at village Sonal, Orandi, Taluka, Aurad, AU, Paredi, district Bidar. It is prayed to direct the authorities to consider the representation dated 31/8/18 made by the petitioner. In that respect. Full stop. The subject matter raised in the petition is entirely in the domain of executive. The pros and cons for restarting the irrigation project would be considered only by the authorities concerned. Full stop. The issues are in the technical realm. Full stop. Such a prayer and the petition in the nature of public interest. From a vaguely filed in a vague manner, would hardly be entertained. The petition is not only paragraph. This public interest petition is not only misconceived, but also filed with a cursory approach. Also, it is dismissed with cost of ₹5,000 to be deposited by the petitioner, to be paid by the petitioner to the Karnataka Legal Aid Services Authority, Karnataka High Court Legal Services. Yes.
Bill number 103, so 230 mat. 103. Mr. Saurabh RK.
What is that?
Lords, there are two writ petitions which were filed before the learned single judge. One was challenging the orders passed by the regional commissioner dated 13/7/2021, by virtue of which the regional commissioner says that my vendor's predecessor in interests title is required to be established, and therefore I am relegated to the civil court number 1. Secondly, my lords, an extent of 2 acres 35 guntas of the very same property was sought to be usurped. I would very cautiously use the word usurped, my lords, by the government for the purpose of its allotment to the Shimoga Institute of Medical Sciences, which is this property. So that was also subject matter of challenge in the second writ petition. Lords, these two writ petitions has been dismissed, my lords, against which now we are before your lordships. May I take your lordships to the facts of the case, my lords? I'll quickly take your lordships to the facts of the case. Lords, one Wesleyan Methodist Missionary Trust Association transfers huge extents of properties in various places in Shimoga district under a registered document of 12/6/1993, which your lordships will find at page number 124, volume 1. Volumes could you? There are 4 volumes, my lords. My apologies that I'll be shifting between the volumes. B.K. Ravichandran versus Union of India. The description of the property is at page number 145. Lords, it commences from S1, it goes on up to S10. But if your lordships were to see, S1 is a very huge extent of property. North to south 530 feet, on the western side, eastern side 425 feet, east to west on the northern side 860 plus 120 by 1140 plus 160 plus 860. As apparently it can be found, it's a very huge extent of property other than the other properties, which is part of the Durgigiri extension. This is called Notes as the mission compound. This entire area, notes, is called as the mission compound. This extent of the property, notes, is reflected in the revenue entries. That is the municipal records at page number 785 at volume number 4. S1 to S8 are the properties referred as mission compound properties of Durgigudi extension.
Possession is ended over.
Lords, this property, lords,
Possession is not
Westland,
ended.
Possession, we are in possession, the state is in possession.
I,
State is in possession.
State is in possession.
or state,
Possession is not handed over to you.
Handed over, my lord, and we are constructing.
lords,
That is
the,
what we are asking.
Yes, yes.
lords, the Sims,
We have
the
produced
person,
photographs. Foundation is laid.
So-
The ground floor, my lord, is ongoing.
What is there to show that you were handed over possession by the state?
My lord, we have produced, my lord, our impeding application photographs are produced.
but impleading applicant is a contractor, my lords. He's a contractor. He's a contractor in respect of the property which is claimed by the government to itself and then handed over to Sims. Sims calls for a tender and then the person who is now getting employed as a contractor. I really fail to understand what is the interest of a contractor in this dispute. It's my, yes, if in case,
You are a contract.
yes,
All right.
not even remotely concerned.
So number 4 is represented by whom?
Between myself and the government.
Yes, my lords.
Who is constructing the cancer hospital?
The cancer hospital is being constructed by the government itself, but then the contract.
Government itself.
Yes, my lords. The government itself has taken up the, because there's the 4 districts do not have a single
You are
bedded
government.
cancer hospital.
You
and
are
it is-
government advocate.
I'm the government. So hence, my lords, we had proposed an 100-bedded hospital to be constructed.
Let them find the government's property and give it. Why in a private property is the question which we raise before the single judge. Not, I demonstrate my case.
Now the decree was passed in respect of same property.
Yes.
Minutes. Decree was passed in only insofar as 8 strips of land.
8 feet of.
8 strips of land consisting over 8 feet.
Feet of land. One
Please.
piece of land consists of 8 feet.
Please.
8 feet.
Yes,
feet.
Lords.
Where is that?
And not get that at.
From the judgment, it is not possible to call out that it is, the decree was only for. So according to you, the subject matter of decree was different land,
Please.
different than one is granted
Please.
for the purpose of hospital.
Please.
So that you show.
Yes,
May I just demonstrate my case, Lords?
We'll hear you.
I'll show you. Lords, may kindly come to page 60, Lords.
Page
60, Lords.
8 feet strip, yes.
Please, Lords.
The suit in OS number 135 having been dismissed,
Came to be partly
came to be
allowed.
partly allowed in RA number so and so, declaring the petition to owner of 8 feet strip.
Please, Lords. 8 feet strip of land.
Now, how will we be able to demonstrate that this 8 feet is not part of the grant?
The reason is this, Lords. The area which the hospital is built upon, my Lords, if my Lords kindly see the deed of indenture, which my learned senior friend just read, my Lords. I think page number 20.
One 124.
It says it's a deed of indenture, wouldn't indicate what is the nature of rights they have over the property, the Wesleyan Church, to hand over them the property. And properties are indicated site-wise, not site number 1 to site number 20. May produce the copy of the sketch, my lords, which indicates the sites which are indicated in this deed of indenture and the place in which we have proposed now to form the or construct the cancer hospital is completely different. That is what the learned single judge also holds by stating that those are two different areas, and the area on which the appellant is now claiming does not fall in within the area where the hospital is proposed to be.
Lords, this is essentially how they misled the honorable learned single
Please
judge.
repeat what you are submitting.
Sorry, Lords?
What you are
Lords,
submitting.
the area which is being indicated in the deed of indenture and the area which is proposed to be built for a cancer hospital are two different areas, is what the honorable learned single judge also would hold. To say that this, I can produce the sketch, which indicates that the site numbers which are indicated in the deed of indenture are clearly demarcated other than the place where the hospital is now proposed to be built.
Indenture is in favor of the.
Indenture is in favor of the appellant, but then those are different lands. Because
So, from record, you can demonstrate it.
yes, my lords.
But may just, but there is some missive which the government undertook, my lords. Kindly permit me for 5 minutes.
We'll consider.
Because what your lordships, my lords, this is essentially my grievance in the writ appeal. My lords, what they did before the learned single
Page
judge, my
number-
lords. This is essentially my grievance. My lords, now again, my lords, the learned single, lords, the whole difficulty was this before the learned single judge. Lords, what we said is, geography will not change.
Going to hear you full.
Very well, my lords.
Page number 888 is what my paper book.
Page?
888. No?
888.
Volume 4.
Volume 4, page 888. No? No, 888. Page number 7. Different.
This is that. Correct again, page number.
888, correct.
Sketch 3.
Yes, 672 here.
Correct again.
My lords, may take it 672, my lords. There's some mistake in the page number. Yes, my lords. Now, compared to this sketch, the deed of indenture is seen, my lords.
It's showing the 8 strips of land. below.
Yes, my lords. The numbers are indicated in this sketch, which corresponds to the deed of indenture, which my learned senior friend read, my lords.
How do
Page
we
number
do that?
140 and odd, my lords.
That's,
It starts at page number 136, my lords. It reads as Shimaga Area Council. My lords gets it at page 136, my lords.
Hmm.
It starts by Shimaga Area Council, S1 on the left-hand side, my lords. If my lords may kindly permit me to point that out in the sketch, my lords.
Hmm.
In the sketch, my lords, in the middle portion, S1 is indicated, my lords. Next to serial number 9, that's site number 9 and 56. In between site number 9, 15, 56 and 27. S1,
open what is sketch.
S1 is indicated, not.
Hmm.
Next is X2 in the deed of indenture. In the sketch on the right side, top, my lords, is S2.
What is S2?
Site number, my lords. They have given S2 is site number. And the description of the property with respect to the area is also mentioned in the deed of indenture. Likewise, my lords, is the next page, which indicates site number 3 to site number 8.
So that the 8 feet land
Yes, my lords. What I'm trying to establish is, my lords.
separately identified.
Yes, my lords. What happened was,
It is in their possession.
the
According-
8 strips is of course in their possession, my lord. These lands which they claim that have come through the indenture is a different land. The lands which they went before the Honorable Civil Court to say that their land should be declared, which was declared subsequently after dismissal in the original suit and in the regular appeal as 8 strips of land, which the Honorable Learned Single Judge also 8 feet of land also would indicate it's a different land. And they are claiming these lands which are there in the deed of indenture overlaps on the area which we have now identified to be for building of a cancer hospital. That would, my lords, would come in the very same sketch, my lords. In the bottom portion, my lords, the triangular shape, my lords. I've also indicated in that very sketch, my lords, the 8 feet of land which they are now claiming through an order passed by the Honorable Civil Court, my lords. In the very sketch, I have marked that portion, my lords, along with the OS number, my lords, 13/59. And the order of the learned Honorable Munsif, my lords, 22nd of January, 1963. This sketch, what I have produced, my lords, is a part of the proceedings before the Honorable Civil Court. That is the indicative of the fact in the very last thing, Exhibit P9, my lords, the date as well as the document produced by which Honorable before the Honorable Civil Court.
This is part of the record of this.
Yes, my lords, Exhibit P9. Whatever is now referring to is not Exhibit P9. Exhibit P9 is that page number 727.
What the government did is that exhibit P9 they took and they themselves marked S1. If your lords were to take 727 for a minute, the same sketch. Lords, now I am very happy, my lords, that the government concede that there is a strip of property which they have demarcated as the 8 feet property, which belongs, which is the subject matter of the earlier suit. I am very happy about it that they conceded to this extent. Lords, now the 8 feet of property is a property which was sought to be encroached upon by the municipality from the eastern side to the western side. Kindly have a look at that sketch for a minute, my lords. I'll demonstrate and then go to the merits of the matter. So that if your lords were to understand the topography, it becomes easier for me to demonstrate, lords. Kindly have a look at the same sketch. Lord's Lordship gets that sketch, Lords. On the right-hand side, the Lordships will find they have marked it as OS number 135 of 1959. This is the 8 feet property, Lords, which is subject matter of the earlier dispute. I'll just demonstrate. If your Lordships were to find, this is a small strip of property which is running north to south. From top to bottom, your Lordships will find that this is the property which was subject matter of the dispute. Absolutely no difficulty. It was about 8 feet. Now your Lordships may kindly come to the schedule of that plaint or the decree. Now that they are lying upon the decree to identify my property, which is 8 feet, they should be bound over by the decree which was passed. Lordships may kindly take the decree at page number 762. Volume? Volume 4, my lords, page 762. Lords, the typed copy is available. Lords, I'm sorry. The typed copy is available, my lords. I am referring to page number 768. Lordships will find the bottom of the plot of the land situated in Shumaga, Devurgudi area marked by the letter CDEF in 2-figure plot of 6 lands, marked by the letter ABCD in the plain sketch, bounded on east by municipal land, west land belonging to the plaintiffs, north circuit house, south by Magga Hospital Road. Whatever is situated towards the western side of the property, which they have now identified as the 8 feet property, which was subject matter of the dispute, is essentially the property which was demonstrated and described as a property belonging to the plaintiff way back in the year 1959. Lordships may kindly take notes, page 768 and this sketch. I'll just be in a position to demonstrate, just to indicate the topography, my lords. That strip of property government identifies as the subject matter of dispute in OS number 135 of 1959. That strip of property which runs from north to south, 8 feet. Notice what happened. On the right hand side, your lordships will find there is a courthouse, circuit house, etc. is there in the same sketch. So those were the properties when they were utilizing it. They utilized another 8 feet for which I filed the suit. My predecessor in interest had filed the civil suit. Where ಹೋಗ್ತಿದಾರ? Well, this is just to indicate the topography, notes. My case lies somewhere else. Notes, after this indenture was made, khatas were standing in my name, in the name of my predecessor, thereafterwards in my name. The total extent of property for which the khata stood is 11 acres, 30 guntas. I'll demonstrate from the records, notes. Just another 2 minutes, I'll take your lordships. Just to give a brief history of what happened. For this 11 acres, 30 guntas, there were disputes which arose at an earlier instance. The competent authorities under the erstwhile Town Municipal Council passed an order saying that this property does not belong to the municipality. This is the property, private property of the CSITA. Khata was directed to be continued in my name. After this, there was a reference to COD. Now, corps of detectives was required to submit a report regarding this very property. There were 2 charges. One of the charges was pertaining to this property. Corps of detectives gave a report saying that the charge in respect of this property is not well founded. This is a private property belonging to the CSITA. And whatever layout or whatever sites they have sold is to the members of the community. That is the people who are members of the CSITA or the particular community, it was given. Now, these proceedings came to be closed in the year 1994 itself. So there was no difficulty. 94 up to 2000, there is no difficulty, minutes. 2000, fresh round of proceedings starts. How it starts is, the deputy commissioner says that there is a report of the COD pertaining to this property. You take action pertaining to this property. COD's report says there is nothing wrong, but deputy commissioner says you take action pertaining to this property. There, certain persons who are not concerned with these properties participate in the proceedings. Adverse orders were passed, as a result of which we came before this honorable court. This is the first round of litigation where we stepped before this honorable court. Notes, I'll be taking your lordships to 4 rounds of litigation. One is the civil suit. Second is the proceedings which took place under the provisions of the Municipalities Act. Third is the writ jurisdiction, minutes, which was exercised by this honorable court. While disposing of the writ petition, the learned single judge of this honorable court recorded a categorical finding in the presence of the municipality that this is not a property of the municipality. And this is not a property which is claimed by the municipality at any point of time. So therefore, the matter stood remanded back because there was some adverse orders passed. The matter went to the deputy commissioner. It was converted from TMC to CMC. As a result of which, it is said that from the deputy commissioner, the matter stood transferred to the regional commissioner. The regional commissioner now passes an order saying that my predecessor's title requires to be established, therefore you go before the civil court. But what is very, very conspicuous of the findings which is to be noted of the findings of this regional commissioner is, he does not return a finding that this property belongs to municipality, nor is there a whisper that this property belongs to municipality. We are speaking about 11 acres, 30 guntas. There is no square inch of property available in excess of this 11 acres, 30 guntas. The specific direction by the regional commissioner is, it should not be alienated and to maintain status quo pertaining to this very property. And it should be mentioned in the khata, which are the khata extracts which is pertaining to my property, that the present disputes is there and we are being relegated to the civil court. This is essentially what was directed by the regional commissioner. In the teeth of this order, which is passed by the very government of authorities, well, so one day exercise takes place. On one fine day, that is 16/7/2022, the muhurtam is fixed. On that day, an endorsement is made in the property register saying that there is an unnumbered vacant strip of property lying in the heart of Shimoga city. Therefore, we are assuming that this is a property belonging to the municipality. We are assigning this number. This is on 16/7/22. On 16/7/2022, this very property is sought to be handed over to SIMS. That is subject matter of challenge in WP number 16857 of 2022. These are the 2 writ petitions. Regional Commissioner's order, which is challenged, and the allotment of this property in favor of Shimoga is challenged. Now I'll take notes to your lordships to the first round of litigation which culminated. Your lordships may kindly take the first of the document which I refer to is page number 785, which indicates the total extent of the property for which there is a khata in my name. 785 minutes at volume number 4. Yara? Total measurements. ಇದನ್ನ ಮಾರ್ಕ್ ಮಾಡ್ಕೊಂಡ್ವಲ್ಲ ಅವತ್ತು ಖಾತಾ ಸಮಯ ಎಷ್ಟೊಂದಿತ್ತಲ್ಲ. Notes, kindly permit me notes. the khata numbers for which the khata stood in my name, but is, I just make the mention of khata numbers because this is already there in the khata extracts of the year 1983 and onwards, which your lords will find from page 495 and onwards. Sorry, page number 502 and onwards. Yes, sorry, there was some mistake on my part in marking the page number. 509. 509. Volume 3. Lordship gets minutes, page 509. Your Lordships will find that all the competent authorities minutes under the Act have signed are the signatories to this, including the Commissioner. The right hand side is the Commissioner. The total extent of property for which the khata is standing for 2015-16 is 4,96,754 square feet, which constitutes 11 acres, 16 guntas. Now the khata numbers for which this property is standing for 11 acres, 16 guntas is not in dispute. Now the first round of litigation, I'm only indicating, minutes, that the khata was standing in my name as on the date when these proceedings started for an extent of about 11 acres, 30 guntas. First round of litigation, minutes, commences at page number 767, which I have already read to your Lordships, minutes, I'll not be repetitive, which is that decree. Notice what happened. I own this huge extent of property. On the eastern side, there was an encroachment by the municipality. Suit was filed against the municipality saying that there is an 8-feet strip of property which is running from north to south, over which they are seeking to encroach upon the property. Commissioner was appointed. The commissioner indicated that 8-feet strip, which I was indicating in the sketch, is the property belonging to me and it was sought to be encroached upon by the municipality. Therefore, the suit was decreed. In the decree, my lords, it is specifically stated the property which is falling towards the west of the entire strip of property is the property belonging to me. That is my predecessor, now presently belonging to me. This is where, my lords, this entire 11 acres, 30 guntas is situated. Now the second round of litigation commences at page number 370. At volume 2. 370.
Statement of objection. Nothing in what they have given, the pages don't tally. I don't know, my learned friend is saying all kinds of things.
My lords, impleading applicant, we have not served any copies to them. I do not know where they have got these copies from. I have not given any copies to them.
Then,
Yes, I don't know where they have got these copies from. Page 370, my lords. Notice the findings in this is of some significance because there is categorical finding that this entire property of 11 acres, whatever I am now referring to, for which the khata stood in my name, does not belong to the municipality, is a finding which is already recorded by the municipality. Page 370 at volume number 2. Page number 381, my lords, is where the issues are issue number 1. Lordship gets it, I'm sorry. Page 381. It's page 381, may I draw your Lordship's attention, my lords. In volume 2. Now the issues which I have to decide is, the objector have raised the land as open space, whether it belongs to CMC or Church of South India Trust Association. (381). The middle of the page, my lords. Now the issues which I have decided is, the objector who have raised the land as open space, whether it belongs to CMC or Church of South India Trust, whether all the places which are mentioned as open space are the properties of CMC. Then the khata numbers are mentioned at page number 382. Now your lordships will find, lords, the findings which is at page number 395. The last paragraph at page 395. In the documents produced, may I just read it, my lords? In the documents produced by the Church of South India Trust Association, showing that the disputed places is not CMC place, nor at any time it was a playground, and this place belonged to Church of South India Trust Association. And this place is in the name of Church in the South Association in MK number so and so is mentioned clearly in the CMC records, and showing that this objected place is always in the possession and enjoyment of the Church of South India Trust Association, and at any time it was neither public property nor CMC property as discussed above, without any room for doubt is clear. And not even one document is produced by the objectors to support their arguments, as there are several documents, not authenticated documents, since it's not possible to believe them. This is an exercise which is undertaken under section 110, 114 minutes of the Municipalities Act, vests the commissioner with the powers to decide when the khata is challenged. This is an exercise of power which is undertaken. Categorical findings is recorded, my lords, by the very same authority, saying that this is not the property belonging to the municipality. Then two, my lords, is simultaneously, your lordships have found, my lord, there were two names which I referred to. Adishesh and Sampath. These two are the troublemongers in the year 93-94. Now, they themselves had initiated proceedings, my lords, as a result of which there was a reference to the Corps of Detectives, which your lordships will find, my lords, at page number 417, 417, at volume 2 itself. It's 417 is the translated copy of the COD report of 15/9/1994. Charge 2 is at page 421, which is pertaining to this property. At page 421, minutes. The applicant in this petition have stated that the Church of South India Trust Association mission compound belonging to the mission compound about 10 acres of land have formed the layout and have sold sites. Have alleged that this is a mayor and deputy mayor have gone forward for issuance of khata to the people who have purchased the sites. And on these alleged during the inquiry that Mahanagarpalika assessment register was verified, in the name of CSI Trust Association during the year Khata number so and so itself is disputed. In this vacant site, CSI Trust Association have formed sites and sold same. It is also come to the notice that that site never belongs to the Mahanagar Palike. In Shimoga city, belonging to CSI Trust Association, all land details being registered in Bengaluru City Civil Sub-Registrar, and this details of Shimoga Mission Compound properties. And this mission compound is called as Durgi Gudi layout, and registered document at page number so and so, these measurements are provided. Disputed land towards the west of adjoining Bhair Singh Tank Road, and it's measuring north to 238 feet, south so and so feet, and being converted into sites, vacant sites adjacent towards the eastern side of Tungbhadra Sugar Factory Guest House. And in this place, the CSI Trust Association have formed 12 sites, and in the said layout, the Commissioner of Urban Development Authority Shimoga have given approval sanction. And further on 18/191, the developmental charges, water fees collected by the Urban Development Authority, issued receipt for number so and so, period collected land revenue so and so. Notice, I'll skip this and then come to the findings. At page number 427, the third unnumbered paragraph, the last paragraph, notes in this. The allegation that the CSI Trust Association in Shimoga Mission Compound CMC are making layout, selling sites is not true. Applicant claiming that the land belongs to CMC, the land belongs to CSMI Trust Association, the said land is in possession on the enjoyment of the CSI Trust. Further, in the CMC register, it is entered as Khata number so and so. CMC themselves say that the land is not the land of CMC land. Hence, with the above materials, the allegation is not true. And the conclusion, my lords, is at page number 429. Totally with the COD inquiry report, charge 1, 4 and 12 is proved. The remaining charges are not proved. Charge number 2 is not proved. Now, this becomes gains significance because whatever difficulty which I am now facing today is only on account of this COD's charge sheet. Now, lords may kindly see page number 567 in volume 3. This is where the whole problem starts for me.
Volume 2 is over.
Pardon me, lords.
Volume 2 is over. Now volume 3.
Lords, may make this.
No.
Lords, even if your lords were
to be seen now.
My apologies, lords. I mentioned in the beginning that I may have to skip over because the documents are produced as petition documents, then respondents documents. In the same seriatim it is there. May I undertake this exercise, my lords? I will prepare a compilation of convenience with reference to only those documents which I am referring.
This is also convenient compilation.
Lords, if I am not troubling your lords, my lords, since skipping over the volumes, my lords, I will. My lords, I completely understand, my lords, that I am putting the court in difficulty. That I am asking your lordships to flip over the volumes. My sincere apologies.
Where is the question?
I'm sorry, my lords.
You're patiently.
Yes, my lords.
But you want to organize your house?
My lords, only that I will just give that convenience compilation, my lords, so that I will not be requesting your lordships time and again to flip over the volumes. I understand.
Because it is equally convenient.
I understand.
Whatever you want.
I mean, your lordship's answer.
You can go on, you can seek time, you can organize the house.
May I request your lordships may have this matter just day after tomorrow, my lords.
Also construct a new house.
Yes, my lords. I'll set myself in order and then come before lordships. My apologies, my lords, that.
When do you?
Matra. My lords, just your lordships may accommodate by 2 days, my lords. I'll be back before your lordships.
29th?
Any day, my lords. I mean, your lordships.
30th, my lords. May I request for 30th, my lords? 30th, my lords. 30th, my lords.
At the request of please learned counsel for the parties, 10/30th.
Please, my lords. But there is an undertaking which may be extended till the next date. It's an interim undertaking.
I had given an undertaking that we will not construct.
They will not put up any construction, my lords.
Till the matter is disposed of, my lords, with an understanding that it will be taken up at the earliest.
Have you recorded anything?
Yes, my lords.
It was recorded in the first day, my lords.
Last occasion also, your lordships, sir.
We have recorded. Oh, you have not. But still seems to mean that we have recorded. All the extended, then it will go to fourth or fifth.
Grateful, my lords.
104. Shirish Krishna.
Appearing for the complainant, your lordship. Your lordship, on the previous hearing date, the respondent have filed their compliance affidavit in this contempt matter, your lordship. We have gone through the contents of the same, your lordship. While they say that they have considered our representation and thereby complied with the order of the writ court of the single bench of the learned single bench, your lordship,
Yes.
your lordship, so if the matter is to be disposed, we crave liberty that we may be allowed to challenge the endorsement dated 27/6/2004 that they have produced along with the compliance affidavit.
Lords, we have filed a compliance affidavit, my lords. Please, my lords, and their representation has been considered and an endorsement has been issued, which is at page 9 of the affidavit.
So counsel is withdrawing.
Your lordship,
You are withdrawing. Mr.
your lordship, the matter may be disposed, but granting liberty to us to challenge the annex endorsement dated 27/6/2024.
The direction of learned single judge was to decide the representation of petitioner. Full stop. In the compliance affidavit paragraph filed by the respondent, it is stated that presentation is decided. Full stop. Endorsement dated
27/6/20.
27/6/24. Deciding the representation is produced. In that view, from a learned advocate for the petitioner, the complainant could submit in view of the complaints from a learned advocate for the complainant petitioner was not in position to press further the contempt proceedings as it does not survive. Accordingly, it is disposed of. It is clarified that if the complainant has any grievance about the merits of the decision taken upon representation, we open to petitioner to challenge the same in an independent proceedings on its own merits. From my respect of which this court does not express any opinion.
Number 105.
Lords, in this matter also, we have filed a compliance report. 50%.
But there is a direction to reinstate responded complete not within a period of 15 days. Not I am entitled for 100% acquisitions. But my lord will find the order at page 33.
Correct.
There are 5 and 6 and 7.
So this is the same thing where within 15 days.
Please, my lords, I have produced the order of the Honorable High Court, the day we have received and the day we have sent to them. My lords, I have in my compliance affidavit, my lords, the lordship may kindly take page 11, wherein the details of order received is available. Lordship may kindly get it at the bottom. 2/8/2023 is the order that we have received, page 11 of my affidavit.
11.
11 minutes.
The order was dated.
That's the order is dated 18th July 2023. 18th July 2023, my lords.
So 2nd August was to be the last day.
Yes, my lords, we have received it. The Advocate General's office has received it on 2/8/23.
When?
2/8/23, my lords, as per this acknowledgement, my lords. And then we have sent it to them and they have received on 4/8, my lords. The letter of the government advocate along with the order has been sent to them and they've received on 4/8/2023. And within 15 days, government order has been issued.
Page.
My lords, the government order is on page 14. And it is 16/8, my lords.
Within 15 days.
14 days, my lords. And now, my lords, I have documents to produce that we have released that 50% of the amount also to the complainant.
Lord, may I submit this? Lord, kindly come to the direction of this honorable court, my Lord, which is at page 33. Lord, it says that, Lord, I am entitled for 50% of back wages if reinstatement happens within 15 days. If not, my Lord, I am entitled for 100%. Lord, kindly come to the rejoinder affidavit filed by the complainant at, my Lord, page 11. It is the opinion which is tendered by the, my Lord, government advocate at, my Lord, Tumkur. He says that, my Lord, order copy is received on 26/7/2023 by the, my Lord, state government, and 18/8/2023, my Lord, the reinstatement takes place. That is after 15 days. That is on 24th day, my Lord. May I read, my Lord, at page 11. In respect of the order of the court, I have perused the documents, order and other related documents. The Honorable High Court has directed in writ petition number so and so, wide order dated 18/7/2023, that Sri M.G. Nataraju, Village Administrative Officer, Naga K. Hubli, Pavagada Taluk, be reinstated into service and granted annual increment, which is withheld from 1/2/2001. The Honorable Court has further directed that reinstatement, if made within 15 days, M.G. Nataraju is entitled for 50% back wages. If reinstatement is after 15 days, he is entitled for 100% back wages. The certified copy of the order is received on 26/7/2023. It is their opinion. Lord, I have not requested to send, Lord, for the opinion. This is dated 6/6/2024. Lord, order is received on 26/7/2023 by the state government. And, my Lord, this honorable court has also communicated through Lord, page 34 for a moment in the contempt petition, my Lord. Immediately, Lord, after dismissal of the writ petition of the state government, Lord, through mail, my Lord, it is communicated to the government, which is at page 34. Lord, they cannot say that, my Lord, on only it was communicated on 4/8.
May I submit?
That, Lord, that is factually incorrect. Lord, the letter dated 6/6/2024, Lord, written by the district government advocate Tumkur, indicates that it is communicated to the state government on 26/7/2023. Reinstatement is on 24th day. And my lord, even till date, my lord, no backwages is paid to the complainant. Order of reinstatement is passed on 18/8/2023. But even after 1 year, 2 months, no backwages is paid. Assuming for a moment, my lord, it is 50%.
You now paid.
It's paid.
Till yesterday, my lord, I have inquired, it is not paid.
Papers.
Why don't you find out?
Yavat payment?
1510.
No, we believe that you want to ask your client
I'll,
when you will ask.
but
We will ask immediately, but when you will get the answer.
But I'm entitled for 100% not backwages.
So first you want to verify whether 50% is paid or not.
Yes, I'll verify.
When?
Next week, ma'am.
So after 20th. After 20th.
After 28th,
20th.
after 20th November
That's some inconvenience, my lord, sir.
to 20th November.
Or tomorrow it may be listed.
These will feel more inconvenient if you seek time. Find out by day after two.
Please,
Pledge.
please, ma'am.
Thank your lordship's kind permission.
And
Item 53. Item 53, Milord. Milord, there is a great urgency. Contrary to the act, contrary to judgment of this court, my entire operations have been stopped. And Milord, earlier already 6 weeks time is granted for them to file if there is any counter. Therefore, Milord, kindly have it on Friday.
Lord,
There is great urgency, Milord.
Day after.
Day after tomorrow.
Lord, 26, my lord. Your
Or Friday, any one of the 2 days.
Friday.
Subject to my lord's convenience. Thursday or Friday.
First.
Lord, 26, my lord. Tender matter.
Okay.
Thursday is not convenient, then let it go to 28.
No, Thursday, my lord. I'm okay with.
Lord, 26, my lord. The
Yes.
The 26, my lord, the matter will become infructuous. Lordship, see, my lord, on the very election day, on the date of code of conduct, the tender is issued and they are about to finish the tender, entirely illegal, my lord, ab initio illegal. The matter is listed before your lord. 26, my lord.
26.
Yes, my lord. It had come up, lordships had posted it today specifically, my lord, given the urgency. 2:30, my lord. Sorry, my lord.
You are appellant in that.
Yes.
For the respondent number 3 in that.
He sought time that, my lord, on the other day, even if it is for admission, my lord, lordships granted time, given the urgency, my lord, lordship posted only 2 days hence.
Lord. Not participated to the tender action. So when do you want?
Tomorrow, day after, any date, my lord, lordship.
Whatever date you say.
Tomorrow.
Day
My lord, serial number 46. My lord.
Serial number 26, my lord, day after tomorrow, my lord.
Serial number 46, my lord.
108, your lordship, it posted at 2:30 today. Yesterday I mentioned your lordship, it's been covered by your lordship's judgment. Covered matter, your lord. Yesterday I requested.
Tomorrow 2:30. You for reading. Covered.
Serial number 46, my lords. This is where during COVID I had supplied PPE kits to the government. Now there are insolvency proceedings initiated by the banks against me for the recovery of the money, my lords. May I request my lords to have it tomorrow or day after? Some urgency, my lords. If the
5th November.
not serial.
My lord, serial.
A shorter date if possible.
No, 5th is short.
Lord, serial number 23, my lord, it's a fresh matter. Matter pertaining to transfer, my lord. May I request for tomorrow or day after, my lord?
Tomorrow.
My lord, serial number.
There is execution filed by the respondents.
Tomorrow you want. Tomorrow.
62nd matter.
You also want tomorrow.
Serial number
13%.
62nd matter, my lord. If there is imminent urgent senior citizens, the property has been acquired in 2000 and still today the matter has been, the WP has allowed. I have filed the contempt proceedings after first week.
But why don't you iron out your bend?
You are my
You
lord.
must iron out your bend. Yes, Mr. 13%.
36, serial number 36.
Tomorrow you want?
Pension.
Yes, sir.
Tomorrow? Tomorrow.
109, my
First matter is left out. Is
Serial,
posted today. Tomorrow at 2:30.
Please.
First matter, because it is.
serial
You-
number,
My lord, serial,
the lord,
Yes,
serial number 52, your lordship.
tomorrow,
Tomorrow,
tomorrow.
serial number
65. Lord, it has become.
Yes, madam.
serial number 83, my lords, learned single judge rejected the
52.
interim order, my lord. Petition as listed.
52.
Kindly have it on before.
Tomorrow,
Yes, ma'am.
tomorrow.
My lord, serial number
65, my lord, contempt case. It has become infructuous because there is a
Tomorrow or
complaint.
yesterday?
My lord.
When do you want?
My lord, it may be dismissed as infructuous, my lord. That is, it may be dismissed as infructuous.
The infectious, learned
Please,
counsel for
please.
so and so states that the petition will be infectious. In this regard, it tenders memo which is taken on record, dismissed as infectious.
My lord,
Retake you.
serial number 110, my lord. This is the doctrine of pleasure. My lord, any time before the end of the month, my lord,
End of the month.
any date.
At central,
Yes, Central Relief Committee, my lord. The Rajiv Gandhi issue was decided in the month of August. This has been pending.
day after tomorrow at 2:30.
Please, my
Lord,
lord.
interim order may be kindly be continued. Interim order is there, my lord, it may be continued.
In this matter,
Please.
Yes,
the orders will continue till
much obliged.
24th of.
Serial number 69, my lord. That it's with regard to that furnishing of the particulars before the Domestic Violence Court Act. That we have already furnished, against which they have preferred a contempt. That we have already filed a statement of objection. May be listed tomorrow or any.
Tomorrow.
Problem.
My lordship, my item number 91 and connected case is coming tomorrow. Tomorrow, another writ is coming tomorrow.
Also on tomorrow. Tomorrow.
Thank you.
My lords, may I take your,
Yes, who wants tomorrow?
yeah, I'm sorry, my lords, serial number 27 and 28, my lords.
Tomorrow, tomorrow.
Lords, tomorrow, very, I'm grateful. my lords.